We are recording.
Good morning, everyone. Welcome to the Board of Specialization meeting. It's Friday, December 12th, 2025 at 9 a.m. And as a reminder, the meeting is being recorded.
It's 10:01 a.m.
Oh, I'm sorry, 10:01 a.m.
No problem.
And now we go to a roll call.
Polano. Here. Bennett.
Here.
Jenkins.
Present.
McGlory. Present. Record. Here. Termitas.
Present.
We have quorum.
We will now call the meeting to order. Good morning and welcome everyone to the California Board of Specialization meeting. As required by the Bagley-Keene Open Meeting Act, members are to appear visibly on camera during teleconference meetings, except if a member is unable to appear by video due to connectivity challenges. We ask that any members who are present with their cameras off state their name and reasons for not being on camera. Additionally, if a member joins the meeting after roll call, they should raise their hand virtually to notify the chair and the public of their presence. If their camera is off, they should provide an explanation. Members should also raise their hands when leaving and returning to the meeting if they will be absent for more than 5 minutes. Next on the agenda, we call for a public comment. Before we begin public comment, I'd like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to the items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, the committee exercises oversight on the program. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. The committee has received and read public comments, although I don't think we have any.
We don't have any in-person signups, but we do have advanced signups.
Okay.
We have Mark Lester.
Okay. To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers. And as chair of the CBLS, I'm going to exercise the option to limit each speaker's time to 2 minutes. For those who are participating by Zoom video, you should have a function for virtually raising your hand. You'll see a hand icon and it should appear at the bottom center of the screen. If you wish to address the committee, please click on the hand icon now, and the committee coordinator will call on you in the order that hands are raised. For those who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, the number 9. Again, doing so will alert staff that you would like to make a comment, and the committee coordinator will call on you and open your microphone so that you can address the committee. For those who are participating from a notice location, please alert the committee member or the staff, State Bar staff member present in the room that you would like to make a comment. Staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 2-minute countdown will begin as soon as you start your comment. The on-screen timer will flash throughout the final 10 seconds. Okay, do we have anyone that wishes to make comments?
I'm going to go ahead and promote Mark Lester.
Okay.
Go ahead, Mark.
Okay, I'm looking to see if my camera can come on.
It won't allow that.
Oh, okay, not a problem. Good morning. By way of background for the new members to CBLS, my name is Mark A. Lester. Since 2002, I am a California certified specialist in estate planning, trust, and probate law. From October 2011 through September 2016, I served as a volunteer member of the Estate Planning Law Advisory Commission and was the 2015 to 2016 chair of EPLAC. Thereafter, from October 2016 through September 22, like you, I was a volunteer member of the California Board of Legal Specialization and was the chair during the 21 to 22 year. From September 2021 through September 2025, I was asked to serve as a CBLS appointed volunteer member to the marketing subcommittee of the ABA Standing Committee on Legal Specialization, and happily did so. Finally, starting in September 2025, and for the next 3 years, I am now an appointed member of the ABA Standing Committee on Legal Specialization. Through the last 4 years of participation with the ABA, I've been able to interface with legal specialization programs throughout the United States and am able to confirm that what was the 2017 version of the California Legal Specialization Program was the gold standard throughout the country. I reference my experience because for the past 15 years, I have been actively and intimately involved solely as an unpaid volunteer in the protection of the public's best interests by promoting attorney competence through legal specialization. I begin my remarks with the congratulations to you for staving off CBLS's elimination for 3 more years. Last fiscal year, upon learning the State Bar Committee's recommendation to sunset CBLS, your board members held an emergency meeting and crafted a letter to the Board of Trustees protesting the sunsetting. However, CBLS then sat back and took no further action. In 2025, however, CBLS was unexpectedly fortunate in 2 respects. First, a core group of former members of CBLS and law advisory commissions rallied support for the legal specialization program from certified specialists and the LA County Bar Association Executive Committee.
Mark, I don't mean to interrupt you, but you've run out of time.
I will place my comments then in written form and submit them later. The goal here was to ask you to audit the records from 2018 forward. There was $1 million that was borrowed from CBLS funds. I haven't seen anything that shows it was paid back, and you were raising $1.7 million per year.
Okay, thank you, Mark. And thank you for those comments. Is there anyone else? I believe there was only one person who was signed up, correct?
Correct.
Okay. So we'll now move on to the next item, which is the oral report. This is, everyone knows, the first meeting in person for the CBLS, first meeting for 2026 coming year. I'm the chairman, George Midas, and our new vice chairman is here, Damon Junkins. I'd like to welcome him, vice chairman. And we're going to move on to the minutes of the August 29th, 2025 meeting. And does everyone take a moment to review those? Opportunity to take a look at the prior minutes. Yes. Okay. I'd like to call for a motion to approve the minutes. Someone wish to make a motion?
I'll first, Damon.
Yes.
Okay. So the motion is to approve the minutes. Can we get a roll call?
Alano,
Can I abstain? I wasn't there.
Bennett,
Approve.
Jenkins,
Approve.
McGlory,
Approve.
Record,
Abstain.
Sirmitis,
Approved.
with 4 yeas, the minutes are adopted.
All right. So we're going to move on to the next agenda item. This is the report on key statistical indicators regarding the legal specialization program. I'll have Janelle take this over.
Perfect. So this is a standing item where we like to provide program metrics to give an idea of the overall program health. We would like to specifically identify areas where we experience a 20% change, increase, or decrease were applicable when compared to last year around this time. So we're currently, as of December 1st, we have 4,641 certified specialists across 11 specialty areas. This is a decrease from last year from 4,752 at the same point, which is expected in a non-exam year. We've seen decreases in the following areas. We have taxation from 260 to 239, criminal law from 278 to 259. We have estate planning from 1,028 to 1,010. We have workers' compensation from 949 to 932, and family law from 1,417 to 1,402. Immigration remains at steady, where no area experienced a decline. Family law and estate planning continue to be represent the largest share of certified specialists. This trend has been consistent over the years and continues to highlight the importance of outreach and other practice areas that we may serve border or more valuable populations. As CBLS considers future opportunities, whether through outreach, program refinements, or expansion into specialty areas, it is important to stay aligned with the board's goal of improving access to justice. And we'll continue to watch closely to see how the October exam cycle influences growth, and we're optimistic on what lies ahead. Next slide for certifications received. We received a total of 91 initial certification applications so far in 2025, compared to 180 at this time last year. This continues a trend where we've seen over the past few months a noticeable decline in applications compared to 2024. In September, we received 1 application compared to 6 last year, and in October, received 2 as compared to 9 of last year. As mentioned in our last meeting, this may be related to the 18-month deadline to apply following an exam cycle, and not all applicants request extensions, which can contribute to the lower volume. It is too soon to tell whether this is a long-term shift, but we'll monitor closely as the October exam cycle wraps up. For recertifications, we have begun to rebound slightly. We've received 712 applications compared to 878 at the point last year. In August and September, we received 123 recertification applications compared to 162 from last year. And in October and November, we received 101 applications compared to 71. This trend will be important to track over the coming months as we look as ways to maintain engagement with existing specialists and improve our long-term retention.
Can I point something out before we shift from the slide? I think you touched on it, but I want to just make this clear to our members. I think what you were suggesting was when we look at November and it's 91 individuals, about half of the total from 2024. That may indicate a decrease in engagement, but it's also likely to be kind of the cyclical nature of the initial certifications, because we would expect kind of immediately following the results of an exam. So we had an exam in October 2023. Results are released in March of 2024. So we would have expected kind of a high number of initial certifications in 2024 and then a tapering off as time goes by, right? So I think seeing these numbers after the release of results in March 2026 will tell us something about the kind of the next cohort of applicants. So I just want to underline that, so that this doesn't necessarily raise like red alarms that there's a 50% decrease. It may just be indicative of the kind of trends, that kind of the cyclical nature of the application process.
Have we seen that in the past, like prior years, that kind of fluctuation?
I think that trend, yes, but I don't think we have the numbers to like do a direct comparison here. Mm-hmm. But Janelle said it, when someone passes the exam, they have 18 months to submit their certification. So we're from March 2024, we are kind of we're at that limit. So that's why we would see like this is kind of hitting the limit as far as when someone could submit an initial application. Okay, thank you, sorry.
No problem. So we move to the applications approved. This is looking at the latest numbers we are seeing. So there was 88 approvals in 2025 compared to 174 at the same point last year. That's a drop up about over 50%, which continues to the downward pattern we've been seeing in the new application admissions throughout the year. We should see an increase come 2026 after the release of results on March 13th. On the other hand, recertifications are trending downward overall, but the decrease is not steady. Some months drop more sharper declines than others. As you see, we have 718 approvals as of 2025, and last year we had 772. That's just a 7% decrease. As we move to resignation, so far in 2025, we processed 118 resignations compared to 148 at this point last year. And that means we're tracking lower overall than last year, which is a 20% decrease in resignation so far. From August 2025 through November 2025, resignations totaled 17 in 2025 and 29 in 2024. Although resignations have varied month to month, the cumulative total of 2025 is still lower from the same point in 2024. Of those resignations, 40% cited other as reasons for resignation. Among the remaining, retirement accounted for 36%, while 24% stated a change in their practice area, tasks and experience, continuing education requirements, and beats. That is it for my presentation. Is there any questions?
Has there ever been talk about maybe having a category for, I guess, government workers or something like that? The reason I'm asking is when I asked some of my coworkers why they took the test but never actually applied was the costs. So maybe that might be something to consider. I know that the bar might lose some money up front, but I think it would quickly gain it back with the increased costs and yearly membership fees.
Damon, just so I understand, so we could take it back. I think you're suggesting for the exam, like application fee, could there be a reduced fee for certain individuals? I don't know the answer to that, but I just want to make sure I understood the question. Then yeah, we can take that back and see if that's something we can explore.
And then I think increased notification of the ability to extend would be helpful too. I know I had to extend, and that was the other reason people told me that they hadn't actually applied, was they just didn't extend. They didn't have really good reasons other than being busy and not asking for it.
So extend past the 18 months.
Yes.
Any others?
Can I ask, I have no idea if anybody knows, but what's the rationale for having the extension as opposed to simply allowing that full period that it could be extended up front? I don't see what purpose that really meets.
The 18th month opposed to being 36.
Oh, so the CPLS discussed that.
That's December, I believe.
I want to say it was 2 years ago. They did draft up a proposal to amend the rules to actually allow for a 5-year results period. But unfortunately, other priorities took place, so it was tabled for the moment. I think as part of the work plan, we are hoping to bring back those proposed rules to the Board of Trustees for approval. But I don't know the history.
Okay.
Actually, but I will say that the CBLS did previously discuss that, and they actually did recommend a 5-year period.
And that has to go though up to the Board of Trustees rather than
To amend, because we'll have to amend the legal specialization.
And since Adrian brought it up, part of the priority kind of assessment that Adrian was addressing, we hired a new kind of a rules-focused attorney at the State Bar to help all of the State Bar teams develop rules for different areas. We now have a new process for kind of raising rules through this process to executive leadership, who then determines prioritization. So all the CBLS rules that were previously discussed and ultimately didn't make it to the board, we're planning on bringing that to leadership and then figuring out where it fits, and so we can come up with a timeline. So we want to explore it but we have to follow this new process. I think we'll be able to report in the near future kind of an estimate of kind of when we can revisit those rules and maybe set some goals for finishing that review.
Okay. So let's move on to the next item, and this is regarding recent developments regarding the board in the state bar.
That's me.
Cody.
Yes, back to me. Well, I'm going to start with probably the update that's of most interest to the board here, and that is action taken at the November 2025 Board of Trustees meeting regarding a previous recommendation to sunset CBLS. What the board determined in just November 2025 is that CBLS will continue to operate as is through at least 2028. This was at the recommendation of staff who really felt like some of the transition of CBLS responsibilities to the CBE was going to be challenging at this time, particularly considering the CBE and boards taking up of a lot of really important topics related to the future of the bar exam, which is quite a lift. So what the board adopted is operation through at least 2028. Another sunset review will occur at that time. We typically undergo a 5-year sunset review. So for other sub-entities, they're set for 2030. But because the board kind of had previously recommended sunsetting, I think it was their the recommendation was sort of framed around the idea that there was a previous recommendation, so this might need to be revisited sooner than the other 5-year review will occur. As far as the next steps, I'm really excited about today's meeting. We have a discussion about the 2026 work plan, and I think it's quite a robust work plan with a lot of really interesting and important priorities. Some of the focus of this work plan is going to be around, again, we're going to be a broken record today, but the board's directive to CBLS to address access to justice issues. So really kind of setting a really strong framework for thinking about our work in 2026, and that will hopefully carry through 27 and 28. I think we'll have some discussion about outreach and kind of expanding the program's reach, especially after looking at some of those numbers. And then some process improvement discussions. We do also have a vacant seat here at CBLS, and so we will, I don't know timing yet, but we will aim to fill that seat as well so that the board is full and that we have full representation. So that is, I think, a very important update, and I'm really eager to kind of hit the ground running with everyone here. Any questions about that update? Okay, well, I think that's great news. Before I move to this next slide, I realized there was actually a piece of the November board meeting that I did not include in the slide, so I apologize. But I wanted to point out changes to admissions fund related fees. So the Board of Trustees at that November meeting considered a staff recommendation to increase fees that go to the admissions fund because of the structural deficit in that fund. You all likely know, but I'm going to just repeat for our audience, maybe at home. Legal specialist related fees are kind of split into two categories. There's those related to the exam that goes into the admissions fund, and then there's fees related to certification and kind of the annual fees that goes into the general fund. So what the board was considering in November was kind of the exam and laptop fees and the other fees folks paid to take the exam. So the board ultimately did adopt a pretty significant increase to the examination fees for legal specialist examinations. For the certification and recertification fees that go to the general fund, those were adjusted by 3%. There's a kind of an annual CPI, Consumer Price Index adjustment that occurs across all state bar fees. So a more modest adjustment there. And then let's go to the next slide. So we wanted to bring an update. We had our October 2025 legal specialist examination. We have some data and some survey information to share with members today. Just to kind of set the stage again, this was our first legal specialist exam that was administered with a combination of live remote proctoring and in-person testing at small test centers. This isn't the first online legal specialist exam. We've conducted online using what's called record and review technology. So that's an individual doesn't have a live human proctor. They have a video recording, and certain technologies flag violations. In the lead up to this exam, we follow our typical exam development process, and I feel like underlining it because it's pretty substantial. We developed 13 exams for each administration. Each of those has 8 essays and 75 multiple choice questions. So, a pretty significant exam development effort that occurs in the 2 years between exams. And we had pretty solid numbers. We conducted outreach to all California licensees to try to reach individuals and solicit applications for the exam. And we had success working with some number of affinity groups and local bar associations to share that information with their communities. I think it's something that we'll talk later about in the work plan. We'd like to do some more targeted outreach there, but really try to lean on kind of our ability to send mass communications through certain listservs. So let's move to the next slide, just some top lines. We ultimately had 398 applicants sit for the exam. 79% tested remotely, 21% tested in person at one of these Prometric test centers. Of all the test takers, about 5% or 18 individuals experienced a technical issue that prevented them from initially completing the exam. So staff worked with them to get back in. So ultimately 17 re-entered or rescheduled, and one chose to withdraw from the exam. We've shared this number with the Board of Trustees. We've also shared it with the Committee of Bar Examiners, who's considering their own exam administrations. And one of the things I think is worth noting is that maybe at face 18 applicants seems like a small number, but the kind of staff and personnel effort needed to get these folks back into the exam in real time is pretty substantial. And so when you think about kind of scaling that out for, or at least for us, when we're thinking about other state bar exams, that really does pose a challenge. And results are going to be released on March 13th, 2026. So those are sort of the top line administration numbers. I want to then transition into some preliminary results from our post-exam survey. Oh, thank you. I'm sorry, I skipped a slide. Here's a breakdown of our applicants by exam. This is essentially aligns with the data that we showed about the programs overall. We have family, estate trust and probate, and workers' compensation areas as being our largest exams. And then we see 0 individuals applied for the Admiralty and Maritime exam, and very low numbers for bankruptcy, criminal law in the federal area, and appellate law in the criminal area. So this is interesting. I think this will also inform some discussions we will have later about kind of assessing existing areas. Yes?
Just a quick question. Is there any current litigation against the exam that occurred this year that will impact the results, or no?
No, there's no kind of formal action or anything like that. And I should point out, those 18 individuals who re-entered the exam, all other than the one who chose to withdraw, ultimately completed the exam with a full set of responses. Okay, let's move to the next slide. Thank you. Okay, so we, every exam, administer a post-exam survey. We are sharing the results that we have now. I'm calling them preliminary because I think you'll see in our work plan discussion, we would like to revisit the topic of how to administer future exams. And I think we'll come to that with maybe the more kind of formalized results across all of the questions that we asked. But for today's presentation, I wanted to just start with some of the kind of the most important questions in the survey and the findings that we've seen so far. And you know what, I'm going to tell you my numbers because that's actually quite small on the TV. I apologize. So the first question was just kind of general satisfaction with the Prometric software. And I should point out, this is the exam kind of delivery software. So both people who tested remotely and people who tested in a test center use this software. So it's really about kind of the interface that they're interacting with. And what we found is that a majority, roughly 51%, said that they were satisfied or very satisfied with the software. But that's somewhat counterbalanced with nearly 3 in 10 individuals saying that they were dissatisfied or very dissatisfied. Let's go to the next slide. We then asked about technology issues, and 3 in 10 individuals, 30%, indicated that they experienced some issue while they were writing their essays for the Prometric software. On the right, we've kind of listed the most common reported issues. Some individuals reported, freezing or unresponsive screen, copy and paste challenges. And then there's that other category at the top. We kind of briefly summarized the kind of open form responses to that other element. And just to point out kind of a few of the topics that we saw there, we saw individuals say that they were attempting to launch the exam and maybe had to restart the software. Others said that they had their screen flashed or had issues kind of with their orientation of their computer screen. We take all of those seriously, and they are interesting. I think one of the challenges in kind of assessing that other category is it's unclear whether some of these issues are platform-related issues or these are really kind of computer device-related issues. And that's important to determine whether this is Prometric platform problem or really just a difficulty with the user's specific device. Okay, let's go to the next slide. Just over 1 in 3 respondents contacted Prometric support. It says during the exam. Let me clarify, because the question is actually prior to or during the exam administration. So these are individuals who may have called prior to the exam because they needed support scheduling their session. They may have experienced a difficulty installing the software, or maybe these are individuals who during the exam faced some challenge. So it runs the gamut. It's a pretty kind of wide net question. But I think what's most important here is that of those who contacted Prometric customer support, the majority of them were sort of dissatisfied or very dissatisfied with the level of support that they received from Prometric. Okay, let's go to the next slide. We then asked if they experienced an issue with their proctor. So we saw that nearly 1 in 3 respondents said that they experienced some issue with their proctor. Again, sort of the kind of most common reported issues among that group that said they did experience an issue would have been an excessive amount of time to respond to a question or issue. Respondents reported that proctors seemed maybe uninformed about the specifics of our exam, or instructions were maybe unclear, difficult to understand, or hard to hear. Again, these are self-reported. We certainly received questions through the State Bar's support lines where there was some confusion about the structure of the exam and how to use the platform that maybe doesn't lie at the feet of the proctor, but still self-reporting concerns we take seriously, and I think it's worth reporting here. Okay, and let's move to the next slide. We also asked a question, did you experience an exam administration issue? The challenge when we create these surveys is kind of how to ask questions that get at the heart of what we want to ask but in the simplest way. I think this question is challenging because what is an exam administration issue? We provided some guidance in the question. We said examples like maybe unclear instructions or delay in the exam day, but it really is kind of a wide net. But regardless, we saw that 1 in 3 respondents said they experienced an administration issue. The most reported problems were reporting that breaks were handled incorrectly, delays caused by proctors or software made the day run longer than expected, or the check-in process took too long. And I just want to point out that check-in process, that's our exam security an environment scan process. So an individual who joins the Prometric platform is asked to use their computer camera to show their testing area. They may be asked to kind of take out their pockets. They may be asked to remove jewelry or hats and things that are prohibited items. So for some, that process was at least perceived to be too long. It's certainly a process that we take seriously and should be done in a kind of a rigorous manner. And then among that other category, some of the most reported others, confusion around scheduling and the practice exam. We did what I would say is a pretty significant level of outreach to test takers. I think we ultimately sent a dozen emails leading up to the exam. So I think that's for us to take back and try to determine what additional information or instructions would be needed. But we really did work hard to try to make communication a priority. On the flip side, some of the other feedback was excessive or unclear communication from Prometric. So even though we worked to send a lot of communication, some actually felt that itself was maybe confusing or a challenge. And then 2 more slides here. We also asked whether or not they contacted us here at the State Bar, because we also have a responsibility to serve as kind of a customer support. Half of all respondents did contact us at some point during the exam process. I want to give kudos to the team. Nearly 3/4 reported that they heard back from the State Bar within the next business day. And I think that's, for a number of State Bar related customer service elements, we aim to respond within 48 hours. So that feels kind of right in line with some of our State Bar wide goals. And then of those who contacted us, 75% said that they were somewhat satisfied or very satisfied with the State Bar's response to them.
Why I see some of it says applying, paying fees, or taking the exam. What were the main issues of why people were contacting the bar?
I'm speaking just to my own experience seeing the cases that come through. There were a number of questions related to scheduling the practice examination. Janelle, maybe you can speak to that a little bit. I know you've interfaced with a lot of our applicants leading up to the exam. Were there kind of more common issues that individuals?
No,
flagged?
it was just more or less scheduling, trying to get a location and such. We were very successful in personally helping them and getting that scheduled and taken care of. So
That makes sense. It just seemed like a high amount, but if it's for that reason, it makes sense.
Yeah, I think to some extent we anticipated this. So of course, changing from one delivery platform to another, for those who are retesting or maybe know people who've tested in the past, that can create a lot of questions. But historically too, the unique population of these test takers has been a population I think has required a lot of outreach and engagement. They are busy working professionals. They may not have used an online exam platform ever or for some time. It's different than maybe our bar exam test takers who are using ExamSoft and they're using it in law school. They have fewer questions. So we did anticipate that's partly why we had a kind of proactive communication approach. And then the last slide is just kind of our overall takeaways. So 57% of respondents said that they were somewhat satisfied or very satisfied with their overall exam experience. I can say compared to kind of our other State Bar exams, that's slightly lower. I think we tend to see maybe 2/3 of individuals being overall satisfied, but it's not way off the mark. What is interesting for future discussions at CBLS is we asked test takers, if you were going to take a test again in the future, how would you prefer? Would you prefer to take it in person at a test center, or would you prefer to test remotely? And we saw 48% would prefer in person, 45% would prefer remote. And that's compared to roughly 8 in 10 who actually took the exam remotely. So there's, I think it tells us that even though a vast majority of test takers took the exam remotely, this kind of 50-50 split on how to proceed in the future maybe is informative for making choices for the next administration. So that's the data, and I'm happy to answer any questions or hear any thoughts.
How many test centers are there by Prometric?
I can't recall the specific number, but it's just over, I think, a dozen test centers that we offered for this exam across the state.
And are there any plans to reduce that number under the results?
I don't think we would want to reduce it. So the reason we got to about a dozen is for the first year law students exam, we also use Prometric. And we have 13 test centers that we use for that exam. And they've sort of been strategically chosen to kind of be in the most populous areas of California. So we've tried to replicate that for the legal specialist exam. And but we may have ultimately ended up with a few different test centers just out of necessity. But I think we have learned a lot about how to cover the state appropriately. So I don't think we'd want to reduce that number.
And the test takers, they took kind of pre-test, right? They worked with the software before. What kind of feedback did we receive at that time?
I mean, the folks who are most likely to contact us are the ones who like really had the most difficulty. And those are hard to diagnose. A lot of the challenges that we hear from or hear of seem to be computer equipment issues. This is somebody who maybe they're using a work device. We tell them to either contact their work IT or use a personal device because of firewall settings. So we heard some of those challenges. We did hear individuals who maybe have a setup at home with a second monitor or something, and that can create some challenges. So we did hear a lot of that. But we certainly did hear from folks who their first kind of line of action is to contact Prometric, and they face some of these kind of customer support challenges. They weren't always satisfied with the level of support that they received, so maybe they contacted us. If it's like a device or technical issue, that's hard for staff to address. If it was, I'm trying to schedule my exam and I'm having difficulty with Prometric, we could take it back to our Prometric like account representative and kind of handle it on the back end. So it kind of ran it's scheduling, it was computer related issues and some reports of software issues, but those are the hard ones to diagnose whether or not it's truly a platform issue or a computer issue. I will say though, and we worked with George and Damon leading up to the exam, we want everyone to take the practice exam before they go into the exam setting, because if they can't get their computer to work ahead of time, the risk of failure during the exam is high. We ultimately do you recall the small number of individuals who did not complete the practice exam? We communicated to them that we would withdraw them, and we ultimately did. I want to say it was maybe 10 or 12 individuals. So by the time we got to exam day, everyone other than those 12 individuals who was going to test remotely had successfully completed the practice exam.
Thank you.
I have a question. Since 48% said that they were dissatisfied versus 52% were satisfied with the Prometric software. So in your mind, is there action steps that we take to go, okay, we need to go back to Promet and look at this? Or is it that this statistic is like, well, it's okay kind of thing? I mean, are there any kind of action steps to see how to overcome these barriers or anything?
Yeah, this is my personal assessment right now. And of course, the members here oversee the exam. When it comes to any action steps related to this exam, October 2025, beyond the 18 individuals who contacted us on exam day and needed our help, we received very few direct comments or complaints about the experience. I recognize the survey is obviously not everyone was fully satisfied with the exam, but we did not have maybe more than one or two individuals contact us to tell us that the experience truly like impacted their ability to finish or anything like that. And like I mentioned, we have complete exams for everyone. So my assessment would be that there's nothing to do yet on it or at all perhaps on October 2025. We have on the work plan, we would like to come back to CBLS and talk about what the next administration looks like and what vendor to use, and also have a discussion about the design of the exam. And we have a good template to do that because the Office of Admissions is working with the CB to create business requirements for exam vendors and then a rubric for assessing exam vendors. And so we would like to come to CBLS and have a similar discussion. And because we actually we would need to create a new agreement with Prometric or another vendor for the 2027 exam.
Okay.
So that's a decision that needs to be made. And I think we want to bring that discussion here with a kind of deliberative assessment process for that 2027 exam.
Seems like a lot of the complaints as well, if I'm interpreting what you're saying right, are misattributed to Prometrics as opposed to potentially just technological, lack of technological know-how, or things that are outside of Prometrics' ability to control.
To some extent, let me couch that with this observation. So of the technical issues that people face, most are probably attributed to something about the individual's configuration, whether it's device, software, like their operating system or something like that. There was, for a small population of test takers, a kind of a platform-related issue that arose during the exam, and that was they went on their lunch break, and we had configured the exam where the proctor would, when they came back from their lunch break, would do the security check without the timer going, so they did not lose any exam time. What happened to a small population was that they came back from their break, they did the security check, and the proctor was unable to restart their clock for the next session. And so we had to have them leave that session and then have them return to the exam in a new appointment. Mm-hmm. So that is, in my opinion, the one issue that we know for sure was a Prometric related issue, and they solved it in real time. Of course, if you were one of those individuals, that was not a great experience, but it was resolved in real time and we were in communication with them. The other concerns related to perhaps like proctoring, those are perhaps well attributed to the vendor. The proctors are a kind of a challenge for our vendors because they are proctors who work on multiple exams. They are getting up to speed with the requirements of our exam. We do offer them like a training document for them to understand the requirements of this exam. But I'm saying to suggest that some of the concerns about the proctors, I think are probably correctly attributed.
Got it.
Yeah.
Thank you.
So they would need more training, the proctors? Walk through. I would say walk through all of the issues that someone is seeing so they can be aware of them and then see them. So that kind of help them to figure out what.
Training is an opportunity. When we were working with Prometric for this exam, they trained this set of proctors specifically on our exam using the materials we provided. So if there was a future where we worked with them again, an ask could be to perhaps increase that training. So yeah, that is an opportunity.
How large was the group that had to have a new appointment set?
It was a portion of the 18 individuals who couldn't complete. I'd say maybe of those 18, maybe 13 or 14 had that issue. And then we had others who maybe experienced some other issue that where they weren't exposed to questions, but they couldn't get back into the exam, and we helped them in other ways.
And was that statewide?
Like, was there a geographic component to it? Yeah, there was not a geographic component to it, but it only impacted remote test takers. Folks in the test centers didn't have that issue.
Okay.
Yeah. Okay. Well, I appreciate the questions. And like I said, I think we'll bring kind of the full set of data to a future discussion to assess the next exam. I think that's the most important next step here.
So let's move on to the next item, and this is a really interesting and I think important area, which is the 2024 Justice Gap Study. And Cody and Erica will be presenting this.
Yeah. Erica's here with us. Erica, I'll let you introduce yourself in a second. Let me set the stage here, and then I'll pass the baton. As I mentioned, I am going to be a broken record. We really want to provide CBLS a lot of data around the access to justice issues that the state bar researches. And so when we worked on the agenda for today, we were really interested in kind of having a few presentations about this data so that when we go into the work plan discussion, you all can kind of think about this information when we set priorities. And so if the goal is to address access to justice issues, one of the great resources we have at the State Bar is our Justice Gap Study that the Office of Access and Inclusion works on. So I'm going to pass it to Erica. She's going to present on the findings of that study, and then I'm going to jump back in at the end and try to connect some dots between the findings and some of the opportunities we're going to talk about in the work plan. So Erica, I'll give it to you. You can introduce yourself and just take it away from there.
Great. Thanks, Cody. Good morning, everybody. Thank you for having me. As Cody mentioned, I'm Erica Carroll. I'm a lead program analyst with the State Bar's Office of Access and Inclusion. I worked as part of a team on our Justice Gap Study in 2024, and I'm happy to spend some time this morning sharing the results and findings with you, and hope you find it helpful in your discussions with your work plan today. So just to go over kind of the components of our Justice Gap Study, we did an initial Justice Gap, we did a Justice Gap Study in 2019, and so 2024 was sort of our first revisit or update to that initial study. And we did this, the definition of the justice gap for our purposes is the unmet civil legal need of Californians at all income levels. So the main feature of the study for us was this NORC survey that we did with the National Opinion Research Center of 6,000 Californians. That was a representative sample of the population of the state. And so it spanned all income levels. And most of our findings come from that. We also did sort of a deeper dive on the needs for immigration legal services. And we did that through an analysis of specifically the immigration findings from the survey, as well as the work of our legal aid organizations that are supported through grants that come through the State Bar. We looked at the civil legal needs of criminal defendants. We did that by surveying public defenders throughout the state about their impressions of the civil legal needs of their clients. And we also did a survey of small business owners in the state as a partnership with the Office of Small Business Advocate. We surveyed 100 small business owners to understand better their civil legal needs and whether they're able to access services, and if not, why not. And then I should say that the way we framed this study was sort of a demand and supply approach. So what I just covered was sort of the demand side of the issue, and then we looked at the supply of attorneys that are available to meet civil legal needs in the state. So we took a look at California's legal market and kind of the various sectors and availability of attorneys to handle individual cases. We looked at attorney deserts, which are defined as fewer than one attorney per 100,000 residents in a given county. And we also looked at pro bono service and volunteerism in the profession. We took a look at funding for legal aid organizations using data from our own grantees. And we also looked at strategies to increase the supply of attorneys and legal services in the state. And so that portion of the survey, of the study looked at the lawyer referral services, as well as incubator programs for individuals who want to go into private practice or small firm practice, particularly meeting the needs of modest means households. And then we also came up with policy recommendations based on the findings, and these were done in conjunction with the Legal Services Trust Fund Commission, which administers grants to legal aid organizations throughout the state and is a leader on access to justice issues in the state as well. So just a brief summary of the findings from the study. we learned that the justice gap remains persistent, widespread, and deeply entrenched compared with when we did the study in 2019. And fundamental barriers that were identified 5 years ago when we did the study initially, we identified that there are serious knowledge gaps and service gaps. And so what we mean by that is that knowledge gaps are folks not recognizing that the issue that they're having may have a legal solution or may be a legal problem in itself, as well as not knowing where to access services or what kind of help they could receive. And then the service gap is just that, that there sometimes is just not enough available supply to meet the need when folks do actually decide to take that step and seek services. So these barriers remain in place. They continue to leave a majority of Californians without the help that they need, and have not changed much since the prior study. The supply of attorneys and legal services available to meet the needs are constrained for a number of factors. So when we looked at the legal market, we found that it primarily serves organizations. Only about 25% of attorneys in California actually focus on serving individuals, whereas the rest of the market typically focuses on corporations, organizations, things like that. So that already is a much smaller proportion of attorneys available to meet the needs of individuals. In terms of attorney deserts, as I mentioned, that's fewer than one attorney per 100,000 individuals in a county. We found that 16 counties in the state would qualify as an attorney desert, which was up from 11 when we last did the analysis in 2019. And we also found that the majority of counties in California are at risk of becoming attorney deserts, except in some of the most populous areas. And so that this is having a disparate impact on folks who live in more rural areas and often lower income areas. We found also that there is limited pro bono service. So 55% of California attorneys reported in 2022, which was the numbers we were using for the study. 55% of attorneys provided no pro bono services in 2022. And that, the share of attorneys who provided 80 hours or more of pro bono service was about 15% of attorneys. So increasing volunteerism is also a need. And then strategies to increase supply of attorneys are promising, but operate at a limited scale. So the incubator programs I mentioned, I believe there's only 4 or 5 in the state, and we don't really have much insight into their effectiveness at this point. And then we have lawyer referral services, but again, there is room to expand their scope, especially to folks of modest means or low-income individuals. So in terms of the recommendations that came out of the study, we sort of grouped them loosely into these categories. Other than the legal aid section, these recommendations are intended for folks at all income levels that in terms of addressing the need. And so we looked at immigration legal needs. You'll see through a lot of these recommendations, one thing that stands out is that we found a need to collect more data and to analyze it. So we have a lot of information, but this is a multifaceted issue, and we recognize that there's more to learn. And so a lot of our recommendations are to engage in that work of doing a deeper dive and understanding the issue even more deeply. So on the immigration side, there was a recommendation to collect data from our state bar-funded legal aid organizations on the common problems to target interventions more appropriately, as well as support the expansion of the DOJ recognition and accreditation program, which allows individuals who are not necessarily attorneys to engage in limited services in the immigration context. On the legal aid side, we're recommending updating and administering an intake census survey every 2 to 3 years. So that is a survey that is conducted by legal aid grantees. They collect every contact that they receive for about a month, and they report out on who they were able to serve, who they were not able to serve, and why, and what their anticipated outcomes are. We're leaning into the use of artificial intelligence to enhance service delivery. So we've already started engaging in that work in terms of responsible use of AI and incorporating it into practice and making it more efficient for service providers. Also supporting the expansion of funding for things like our Legal Aid Leaders Fellowship Grant, which is a law school to legal aid pipeline in terms of supporting folks who might want to work in legal aid over the summer and then creating that pathway to the profession. Pro bono services, as I mentioned, we're looking at the data for that and trying to understand what might be the factors that could promote increased volunteerism. And then also looking at an attorney outreach and engagement plan to help with that. Lawyer referral services, there was a change to the rules, the state bar rules recently that allow lawyer referral services to partner with other organizations. And so we're looking at partnership opportunities with public defenders, with small business, with legal aid. So in a variety of ways that they might be able to get more folks connected with services in terms of increasing their visibility and effectiveness, as well as collecting more data in that regard. And then, as I mentioned, even more data collection regarding these attorney deserts and legal incubator programs. So again, just to focus on some of the numbers from this study, as I mentioned, the justice gap is entrenched and persistent. And so in 2019, we found that 85% of civil legal needs went unmet, or if they received some service, it wasn't enough to resolve the issue. And when we did the survey again in 2024, the outcome was the same. So this number is fairly stubborn and hasn't budged in the past 5 years, and we're trying to understand more about that. One thing that might be contributing to that is the fact that Californian civil legal needs are growing. So when we did the survey in 2019, a little over half of Californians had experienced at least one civil legal problem in the prior year. When we did this survey, when we re-administered it in 2024, that number had grown significantly to 73%. So we went from a little over half to almost 3/4 of Californians who are experiencing a civil legal problem. And then when we asked about impact of these problems, because some of them might be minor and some of them may be major, we learned that a substantial impact was had in over 104 California households when they experienced a civil legal problem. Most pronounced was on their financial situation. It would have a substantial impact on individuals' financial situation, but we did see that with mental and emotional health and even physical health and safety, some folks had negative outcomes or impact. In terms of the areas where folks are experiencing issues, we broke it out by issue area or practice area. And what we learned was that the top issue area reported was consumer issues. 41% of respondents had an issue, a consumer issue, and a little over a third had healthcare issues. So those were the top 2 reported concerns as part of the survey. And we didn't just ask broadly about this. The survey had several issues, sub-issues within these categories to ask about. And so for consumer, what we found was that the top 3 issues were compromised personal information, contract concerns, or personal injury. And then with healthcare, the top 3 were service denials, incorrect billing, and unpaid medical debt. And even though these were really significant proportion of issues reported, only 1 in 10 individuals actually sought assistance, legal assistance for these issues. So there's a high frequency of occurrence, but a very low frequency of reaching out or engagement with legal services on these issues. And so it's an area where I think a lot of growth could happen in terms of service delivery. And then, as I mentioned, we did sort of a deeper dive on the demand for immigration services, which has been increasing in the past year, especially in the legal aid context. We received reports from legal aid grantees that there had been a significant increase in demand for services. And so 9% of California households experienced a problem related to immigration in 2024. And for more than 50% of those problems, folks sought legal assistance, but only received help for about 40% of that. So we identified a substantial gap in this area as well. And part of that is that just 2% of active attorneys in California are actually focused on immigration law. And so I'll hand it back to Cody to talk a little bit about what these findings might mean for CBLS.
Sure. Thank you, Erica, for presenting that. Let me connect those dots that I was mentioning, and then I think both Erica and I are happy to respond to any questions. So looking at those findings, we wanted to summarize a few opportunities, and I want to frame them as opportunities because when CBLS discusses its work plan later, it gets to determine its priorities. So these are not set in stone. But CBLS has signaled it wants to be more proactive in identifying new specialty areas. And the findings from the Justice Gap study, I think, could give us some areas of focus. So personal injury law and healthcare law were recognized in the Justice Gap study as kind of one of the top consumer issues where there is a gap. And these happen to also be areas that are recognized as specialty areas in Texas, Florida, and Louisiana. So these could be some starting places. CBLS kind of always has an ongoing priority to conduct outreach to kind of strengthen the program or expand the program. And I mentioned we did that to some extent for the October 2025 exam by reaching out to kind of affinity bar groups and local bar groups. I think in that effort, we sort of were willing to take whatever support we could get, but the Justice Gap study perhaps provides us an opportunity to have kind of a more focused goal in mind. And so one of the things that we think could be an interesting priority is to try to really focus on outreach to groups that represent immigration law attorneys with the express purpose of trying to increase the number of certified specialists in that area. And at the November board meeting, at least one board member also signaled their interest in kind of doing what we could to increase that area. And then I also wanted to point out an area of CBLS's program or oversight of programs that maybe doesn't get as much attention as it could, but CBLS doesn't have to create new specialty areas to make an impact in this area. It also can accredit other certifying entities who are already doing this work. And so when it comes to outreach, a effort that we could take on is to try to solicit more applications from those entities. And I think, the considerations and balances there are, of course, whether or not that certification entity meets our standards, but also kind of comparing it to the reduced kind of development and staff and cost associated with the state bar in kind of launching a program and maintaining it. There may be some benefits to accrediting certain areas as opposed to creating new specialty areas. So these are a few through lines from the Justice Gap study, some opportunities, and I think they show up in the work plan, so we'll talk more about them as well. But I'll leave it there and happy, I think, for myself and I'm sure Erica to respond to any questions.
This one, sorry. What does Louisiana, Texas, and Florida have to do or contrast the needs of the Legal Services Trust Fund Commission for California? What do those states contribute to our work?
I think the question is like, why did we reference that on the slide? It's not meant to be like a comparison, I guess. With the recommendation to maybe pursue healthcare law or personal injury law is directly rooted in the California data. We pointed that out only to suggest that those are areas where other jurisdictions have determined that a specialty is appropriate. So I think it's just instructive to CBLS to know that if it decided it wanted to pursue those areas, it's not alone in thinking about that. Also, it could also mean that those individuals could be part of any consulting group or could come and speak to CBLS about those programs. So those are opportunities as well.
I have some comments and then a question.
Sure.
And these don't need to be answered, but just things that popped up. Because I'm an immigration attorney. So there's probably low self-reporting for immigration for the need for immigration services because people don't want to expose themselves as being undocumented. So just wanted to point that out. that's generally the case in the community. I don't recommend use of AI for immigration legal services because when I look up answers and AI pops up, it's always wrong. So immigration law is the second most complex area of law, maybe after tax law. Immigration, so when I ask colleagues about why they don't want to, I don't ask them why don't you want to apply to be a certified specialist, but the things that always come up, one thing is what is the value? So they want to know what is the value. But the other thing is that there's immigration laws are really two areas, family-based, removal defense, and then employment-based. And so many of the best attorneys who do, who would serve the needs for these legal access or access to legal justice programs, they are reticent to take the exam because they don't practice employment-based law, which usually requires high volume. And so even though I think they could take the exam and pass it, not having done heavy volume employment-based, because the other questions could balance it out. Just putting it out there, like maybe consider, like, could there be subspecialty? Like employment-based or just family-based and removal defense specialty.
Yeah.
I don't know how that would work, but just that's a big bar to people from applying.
We certainly have other areas like appellate law and our criminal law exam where it's split into two areas because there is that sort of distinction.
So I recommend that for immigration law.
Okay. I don't know, Adrian, you may know, do you know kind of the history of how two exams was determined and developed out of one specialty area?
I don't know the history, but I imagine it's because they're so distinct.
Yeah.
It could be, I could see it as being like discriminatory against if you're not practicing both areas. So they just opened it up for other applicants to be able to get certified in that area. So
I think we could explore that. I asked that question because I don't know what we need to do to make it happen. So that would require further discussion. But we've obviously achieved it before for these other areas, and so we could explore that for immigration.
I noticed that Texas has some split ones. One of them's real estate. They have residential real estate and then commercial real estate, which I think is somewhat similar to what you're expressing. Yeah.
And then the question I had was the list of state bar funded legal aid programs. Like I'm wondering if there's a list of those or where webpage I could look to. This is just curiosity about which organizations and state bar funds.
Yeah.
Yes, we do maintain a list. We currently have, I believe, 114 grantees. And so that is posted on the State Bar's website. And I'd be happy to share the specific link with Cody so he could pass it on to you.
Erica, I could search for it too. Yeah.
Erica and Cody, I have a question. Just under the summary of findings, at the bottom where it talks about strategies to increase supply of attorneys are promising to operate at a limited scale, does that include promotion, marketing, communicate? I mean, does that include the promotion marketing aspect of it, or what is that? Strategies are promising but operate at a limit. Does that include trying to increase attorneys to help that? I mean, could you just elaborate on that?
Sure.
Yeah. Yeah, go ahead, Eric.
That's primarily focused on the use of incubator programs. So as I mentioned, there's only about 4 of those statewide. If they could either be expanded or replicated in order to promote individuals going into, say, solo practice, but focusing on sort of those modest means, middle income consumers who might be able to access services that way, who otherwise might not feel they could afford the services of an attorney. That was actually one of the findings in the study, was that what folks thought they could or should pay for an attorney versus what's actually charged at an hourly rate, for example, there was a wide disparity between those two numbers. So incubator programs, lawyer referral services, which or so folks can, when they're looking for an attorney, but they're not familiar with who would be available to them, they can contact the lawyer referral services, but having those tiers in service available, again, particularly for folks of limited means, that they could contact them, and maybe it's not just legal aid that's available to them, but having other options. And so through those partnership programs, having access and outreach available is part of it. But I wouldn't say that it's specifically focused on marketing that piece of the study.
Kind of related, but some feedback or some things I've heard from legal aid organizations and in the immigration area was the cost of specialization for an attorney. I mean, funds are being tightened, right, in terms of state grants and money, and they don't have a lot of money, and I don't think the salaries overall as high as the private sector. And whether there's a way for specialization or the board to, the board to address that, or maybe there was discussion earlier about ways to reduce fees, whether that could be in relation to certain areas of law to further encourage that.
I second that. Yeah.
Yeah. Okay. Erica, thank you so much for presenting on that.
Yeah, thank you for having me.
Thank you.
Thank you.
Thank you.
Cody, so I think the next thing is relates to the demographics of the current specialists.
Yes, this wraps up our data-heavy front end of the agenda. But again, the goal is really to just provide all this groundwork for the work plan discussion. Okay, and I think I can move through this pretty quickly. So while we're getting that slide up, I'll just introduce the data that we're going to present. We have a number of interesting data sources that we compiled together. One is, if we can go to the next slide. One is our what we call our report card on the diversity of California's legal profession. What the State Bar does every year is called the voluntary attorney census, in which we ask attorneys to self-identify in a number of demographic areas. We take that data, we compile it with federal U.S. Census data and some other data from federal health and veteran agencies to put together a summary of the California attorney population compared to the California just adult population overall. We also have a number of other data sources we use to kind of supplement missing data. So anyone who becomes an applicant to the State Bar prior to becoming a licensed attorney submits to the Office of Admissions some demographic data. And so where there were gaps, we will often supplement that missing data to come up with a more complete picture. So what I'm going to present today are the findings from that data. I just want to point out that what we represent kind of excludes kind of missing information. Individuals are allowed to, for example, select declined to state or unknown to some of these responses. We're not reporting on that here. And just as an interesting note, when it comes to missing data, that tends to be more common among older attorneys. So I'm going to show data of our current active specialists and also our inactive specialists who are presumably, to a large extent, those who are retired. And so I think we would expect kind of the current active specialist data to kind of be more complete and more accurate because of that. Okay, let's move to our next slide here. So starting at a high level of the reported racial and ethnic identity, and I'm going to point out for all the slides, the top bar in blue is our active specialist today. The second in the lighter blue is inactive specialists, so those who were previously specialists and then either retired or personally decided not to continue as a specialist. There's a number of reasons why. The third row, which is our kind of light green teal color, is the attorney population in 2024 when our diversity report card was released. And the bottom one is our adult population in the state of California. So just a couple of kind of comparative points there. So what we see just kind of at this high level is that among current active specialists, 76% identify as being white. And we have just under a quarter of our current active specialists identifying as a person of color. What you can see just kind of comparing to the California attorney population and adult population is that among our specialists, those who identify as white are overrepresented, and those who identify as people of color are underrepresented. On the next slide, we kind of break this down with more detail. What we see here among our active specialists is 76% of them are white, 7% are kind of second category, identify as Asian, 5% identify as Hispanic or Latino, another 5% identify as multiracial, 2% Middle Eastern or North African, and then we have less than 1% identify as either American Indian or Alaskan Native or Native Hawaiian or Pacific Islander. Again, comparing the California attorney population and the adult population, we see our legal specialists are sort of overrepresented. Those who identify as white are overrepresented, but we see kind of at these more nuanced levels underrepresentation for those who identify as multiracial when you compare active specialists to the attorney population. For those who are Middle Eastern, North African, again, underrepresentation when you compare the attorney population, and just a number of kind of other trends when you make those comparisons. And I'm not going to go through all of them, but the materials are attached. If we go to the next slide, we also ask, of course, gender identity. And we see that about just over half of the current legal specialist population identifies as being a man, and about 43% identify as a woman. Even though a larger population of active specialists identify as men, I think what is interesting is that when you compare the currently active specialists compared to the inactive specialists, we see a large increase. So 43% of current specialists are women, 30% of inactive specialists identify as women. I think that's indicative of kind of growing diversity within the program. If you kind of accept the assumption that inactive specialists are perhaps older, or that the current active specialists are newer to the program, perhaps. So that is maybe an indication of some improvement over time, although it's not, direct comparison. We don't have that like trended time data, but I think it does tell you something about changes over time. And then let's move on. We also have a number of other demographics that we ask about in our survey of attorneys. What we found is that 4.5% of active specialists identify as having a disability, 8.7% identify as part of the LGBTQIA plus community, and 4.8% are veterans. Interestingly, those who identify as LGBTQIA plus, pretty steady across active, inactive, the California attorney population and the adult population, perhaps a slight underrepresentation, but I think those numbers are promising. But when you look at areas perhaps as such as disability, we see kind of an underrepresentation amongst active specialists compared to just the adult population overall. And for veterans, we see among active specialists comparable numbers to the attorney population, but perhaps underrepresentation across the adult population as a whole. So let me summarize all that, because that is a lot. I think the top lines are that white individuals are overrepresented in the legal specialist population compared to the state's attorney and adult populations. The inverse of that is that people of color are underrepresented. We did point out, though, that active specialists today are more racially and ethnically diverse than inactive specialists, and that may demonstrate some improvements. Similarly, women remain underrepresented, but we see that increase or that larger proportion in the active specialist population. So that's it on the demographic data. This was, I think we thought, just another, oh, I'm sorry, there's one more slide. I forgot about that. Again, we're trying to connect the dots. So here are some opportunities with this data. And I know it's a lot of data, but we're going to really get to the meat of it soon. So we mentioned that we perform outreach to affinity bar groups and some similar groups. And we have like a large listserv where we reach out to these folks. And we could make it a more concerted effort to focus on certain groups over others and really try to reach their communities more so than others and focus our efforts. Because we see amongst the active specialists more diversity, another opportunity is to focus outreach to perhaps newer attorneys. CLA, for example, has a group of kind of recently licensed attorneys. We could try to catch people earlier on in their career. That also allows them to sort of establish their career journey in a way where they're pursuing specialization. For some, it takes some time to meet all the requirements. And then Mia and the regulation team aren't here today, but to whatever extent our current area standards are creating barriers, the regulation team is working with the various working groups to review those standards, and we may recommend a proposal to update standards to make it easier for individuals to become specialized. And maybe easier is not the right term, but to reduce the barriers, the unnecessary barriers that exist. And again, some of these priorities show up in our proposed work plan as well. Okay, that was a lot of numbers over several presentations. Thanks for bearing with me. Any questions on this set? Okay.
So that leads us to the next item, which is the process for identifying new and assessing existing legal specialty areas. And again, Cody is gonna...
Yeah, I'm sorry. I'm going to pass the baton shortly here. I'm sorry. I hope it's informative though. But okay, so as I said, I think we wanted to provide data to lead up to the work plan discussion, but we also had a lingering discussion from our last meeting where we started to talk about process improvements so that if CBLS wants to pursue specialty areas, it can do so in like an effective, organized way and really, again, meet those access to justice directives from the board. And so I wanted to provide a follow-up of some of the recommended changes that staff would like to bring to you following that discussion. So let's go to the next slide. So as a reminder, here's a list of the things we talked about in that last discussion in, I think, perhaps August of earlier this year. And the areas in red are kind of what our proposed updates, and that'll kind of follow through the rest of the presentation. But we talked about the standards that CBLS has adopted in the past for assessing new specialty areas. And that is attached to the agenda. We have both the current standards, but we also are proposing an update to that standards doc that incorporates some of these access to justice issues, very much informed by sort of the questions that our Justice Gap study asks. We wanted to bring those perspectives and considerations into the standards. So we'll talk about that document in a second, but that's one of the proposals is to update that standard. We did briefly talk about whether the standards should include kind of quantifiable thresholds for certain criteria. So for example, there is for the public application for new specialty area, there is a question that asks how many individuals are expected to qualify for this, for the proposed specialty area. We ultimately decided that like setting like a firm minimum threshold wasn't necessarily appropriate. And of course, CBLS will just assess the figures that are presented at any given time, but we didn't feel like prepared to recommend any specific number. And then we talked about updating the public application. So of course, CBLS can pursue on public can also request that. And one of the things I think we recognized was that the application asked these kind of open-ended broad questions that maybe wasn't giving CBLS all the information it needed to assess an application, and maybe it was making the process less efficient. So what we have attached is also a proposed update to the application. And what our thinking is that if CBLS has clear standards for assessing a program, then the application should have someone respond to each one of those standards as clearly as possible. And so there's alignment between the two documents that we're proposing. And then the second area that we talked about was improving the approval process. One of the things that happened when we brought the privacy law standards to the Board of Trustees is that they felt like they were getting this information kind of late in the process. And so what we're going to show in a moment is a flow chart where we want to bring the Board of Trustees in kind of earlier in the process and capture their feedback before too much work is done. A small inefficiency perhaps is that at least under a policy that exists is that public comment on proposed standards goes back to the consulting group. But we learned through the privacy law area that a lot of the public comment that was received was not substantive. And so we feel like a better approach is that public comment comes back to CBLS, and CBLS can determine whether or not it goes to the consulting group, but try to skip an unnecessary step whenever possible. And then we talked about maybe setting kind of a predefined criteria for consulting group members, but sort of like the quantifiable threshold, I think we decided there needs to be some flexibility on a kind of per case basis to determine who's most appropriate for those groups. And so we aren't proposing right now that predefined criteria. And just that last bullet point is really just the purpose of what I'm about to present. Because CBLS wants to be more proactively engaged in this area, we want to try to create like the necessary guardrails so that the approach is organized and efficient. We can only meet so many times in the year, and there's only so many ideas that can be pursued at any given time. So we want to provide some structure for the board to consider. Okay, let's go to the next slide. So recommendation 1 is update the standards. So I mentioned attached to the agenda, we have our current standards and then a draft version of the standards that we'd like you to consider. Just to kind of summarize what's recommended, instead of kind of open-ended concepts. So for example, it's the original version or current version says that a standard that is considered is the perceived need. Instead, we've kind of we've worked the language a little bit, so it's more like, to what extent does this proposal address or demonstrate a perceived need? So it's kind of more geared towards meeting certain expectations of demonstration as opposed to just kind of these open-ended questions. So that's a small like kind of language choice. We also clarified in the standards that the standards apply to both CBLS assessing a public proposal, but also its own proposals. So the thought there is that if CBLS wants to explore its own ideas about potential specialty areas, that's going to use the same set of criteria for assessing that they would in application. And then we've also added to the standards an assessment of the available entities that already offer certification in the proposed area. So there's a proper balance between understanding whether or not developing our own specialty area is appropriate or working with an entity that already exists. And then we added, as I mentioned, these access to justice standards. So how difficult is it for a consumer to identify competent counsel in this area? Is the primary consumer a person rather than a business? That's this like people law concept that's explored in the Justice Gap study. Is the area recognized as one where there is underutilized or unavailable legal services? And so that could be, through our Justice Gap study, or it could be other kind of research or documented evidence that is an issue in this area. And then kind of this broader category, again, inspired by the Justice Gap study, but would certification in this area improve access to the legal services? Would it positively impact consumers' perception of the legal system? And or would it increase consumers' confidence that accessing legal help can help them solve their problems? That's directly inspired by the Justice Gap study, because those are the challenges or some of the limitations that were identified that prevent individuals from accessing legal help. So we really tried to take some lessons learned from the Justice Gap study and apply them directly to the standards. Let's go to the next slide. As I mentioned, we also want to update the public application. We've made the questions far more specific. So on the current application, it will say something like, describe the perceived need. Instead, the new application says, demonstrate the perceived need by addressing these areas. And then it's, a list of consumer needs. It's a list of, let me bring that up here, but yep. There it is. So it's describe the perceived need through consumer-related challenges, and then we list those consumer-related challenges from the standards. Describe the perceived need addressing the following access to justice issues. It's the same issues that were added to the standards. And we continue that kind of pattern through demonstrating feasibility and demonstrating the available CLE. And it's all just a one-to-one connection between the standards and the application. We've also made some minor updates. We have had a policy that an application needs to include 25 attorney signatures. We've added that directly to the application. I think staff was responsible for telling them that in the past. It's there now. And again, we're also asking applicants, if you're going to propose a specialty area, have you done any research, and can you tell us about any certification entities that already offer these programs? And our hope is that they will bring to us information about the landscape for us to consider. Okay. Yes.
So they would have to have 25 letters of recommendation, so to speak, to accompany their applications?
Yeah, so the way that the application works is they have to have 25 attorney signatures in support of it. Those attorneys do not have to be people who actually want to become certified specialists.
Absolutely, letters of recommendation.
What's that?
So letters of recommendation, so to speak, just shorter.
What's the format? Does it need to be a letter, or could they just compile a list of signatures, essentially like a petition of sorts?
I imagine both would be acceptable.
Okay.
For privacy law, it was just a quick statement. I support this area, and then they signed it.
Okay.
But I think if CBLS agrees, I think a list would be appropriate.
Okay, shorter and sweeter. They kind of validate who's making the request.
Mm-hmm.
Be nice to know why they validate their request, though. I mean, it's only 25 people. It's not like we're asking for thousands of signatures on these.
Confident.
Confident.
And that would be the task. The analyst kind of fall to say the white piece if they wanted more data.
Yeah. Okay. The third recommendation is, again, the kind of a approval process. So in red are the additions, and we've struck out elements that we think could be removed. So we broke down this flow chart we showed at the last meeting where we discussed this. I think, again, it was maybe August. And this has been kind of a resource that we have on file about what CBLS's policy or process is supposed to look like. I've simplified it in some sense to these 5 areas. There's a proposal phase, there's a research phase, there's an board engagement phase that we've added, consulting group phase, and approval phase. So what we're proposing is that I think the way our policy at least exists on paper is that after staff presents research on an area, CBLS determines whether to form a consulting group to explore this further. Yeah, go ahead now.
I'm sorry.
It's okay.
So would this consulting group cost the organization dollars?
There would be staff time attributed to supporting the group, as well as if there's public members. There's the public member premium.
Okay, so no outside agencies that would cost us any funds. It would be total volunteer.
It would be volunteer, correct.
So for like the privacy law consulting group, I think they met 4 times per year. Was that total though?
3 years, I think.
for 3 years, so 12 meetings.
Correct.
So there is some, staff time is probably the most significant factor there. It's also just a lot of gathering of information and presenting of information. So the reason why we've added this step here, which is instead of just immediately determining whether to form a consulting group, let's inform the board about this intention, and let's get some feedback. Because if the board determines they're not interested, we should reconsider. Yes. So we've added that, and then we've added in between this board engagement. And what we're saying is that the Board of Trustees will provide feedback on the proposed specialty area and the consulting group. We're not prepared now to commit to whether that is just feedback or the board wants to make a formal resolution to approve or deny. But what we at least want to say is that it'll go to the board, and the board will determine kind of how it wants to provide some input on this. Once CBLS gets that guidance, then it can proceed with creating the consulting group. And then, as I mentioned, we are removing this step that the consulting group analyzes public comment and then submits any revisions to the CBLS. And instead, CBLS will consider public comment, and it will determine whether it needs feedback before advancing it. And that's what's going to happen today with our privacy law specialty area feedback or public comment. We're bringing it right back to you because it's not substantive, the information. Okay. And then I think we have 5 recommendations total. So this is 4 of 5. So the CBLS is interested in identifying new areas. We want to do this in a structured way, and we want to make sure we get input from all of our members. But how do we do that in a way that we're not just collecting kind of recommendations at many different times of the year and things like that? So what we're proposing is exactly what I think we're going to do here today. Let's discuss whether or not this is a priority at the annual work plan meeting. If the CBLS takes action to approve the work plan, then that is serving as CBLS's motion to initiate exploration. And then, of course, we'll then bring some research back to CBLS at a later date. Prior to the work plan meeting, we'll certainly work with our chair and vice chair to identify some of these potential opportunities so that the work plan at least has some skeleton to consider when we come to the meeting. We did have some conversations like that prior to this conversation. This may be kind of in practice what has occurred in the past, but I'm not sure we've kind of formally adopted this as the approach we are going to consistently take. So that's our recommendation, is to do just that. So then our last recommendation is a new one, but I think it's worth exploring. Actually, if you can go back real quick, Adrian. So we have found that there are specialty areas where over many exam administrations, we have very few applicants sign up for the exam. And the most notable is Admiralty and Maritime law. We had 0 test takers for the last 2 exams. I think we had 1 apply for the exam prior. We are going to have a discussion later today. But I think what we wanted to know is, how do other jurisdictions deal with this? And what we learned is that they have kind of policies or rules that dictate how they assess existing specialty areas. So our 5th recommendation to be considered is to set a policy in place that would lead to the automatic assessment of existing specialty areas. Now, that doesn't mean the automatic closure of a specialty area. It just means that CBLS knows we are going to review every specialty area that meets this threshold, and it becomes a regular cadence in the work that CBLS does. The reason that we want to do that is that it is resource intensive for us to develop exams for areas that don't have test takers or have very few test takers. We recruit subject matter experts, we have consultants. There is a lot of staff time that we don't really have dollar figures for, but it's substantial staff time. So we performed some outreach, and Janelle spoke to some of our partners in other jurisdictions. Thank you for that. What we found is that North Carolina, they decided when they had a specialty area that had low engagement that they would review the standards and the exam requirements and determine whether that was a barrier. But what they found was that when they did that, it resulted in kind of modest improvements. What we learned from Florida is that their Supreme Court adopted a rule where their Board of Legal Specialization would close a specialty area to new applicants if the area does not have an initial certification application for 5 consecutive years. What that would mean is that no one can take the exam and apply to be a new certified specialist, but everyone who's already specialized can continue to recertify and continue to serve as a specialist. And what their policy or their rule then requires is once there are no longer individuals recertifying, that they then propose to the Supreme Court to permanently sunset the program. We want to sort of follow a similar approach, but not automatically close anything. And so what we're recommending is that CBLS establish a policy that if fewer than 5 applicants register for a specialty area in the 2 most recent exam cycles, so that's 4 years, that CBLS just assess whether or not to close the specialty to new applicants or not. And at that time, CBLS may decide that's appropriate or not. So it's not automatically closing it, but that it would undergo some level of review. Again, we're baking access to justice issues into everything. So I think one of the considerations that CBLS should consider when they're making a choice to close a specialty area to new applicants would be whether or not that would have a negative impact on somebody's access to justice goals. And if it does, then perhaps an alternative path would be to review the standards and exam to see if we can have those modest improvements or more out of the program. So, so again, our goal here is just to really bake in a regular review process of existing specialty areas on an ongoing basis. So those are our 5 recommendations. We have a proposed resolution if CBLS agrees, and that is to adopt these 5 recommendations, but I'll cede the floor and happy to hear any feedback or take any questions.
Will there be an automatic review as well to look at whether there should be new or added specialty areas so that that's, at least in our minds and ongoing?
Yeah, I think the way that these recommendations are worded is that would happen every year at the work plan meeting. We would determine whether to explore specialty areas. We would identify if there are certain areas that kind of already have floated to the top. We could identify them explicitly if we want. And that's what we're going to, I think, do today later in the work plan discussion. So I think new areas come up annually during the work plan discussion. Existing areas are assessed only when this threshold is met.
Thank you.
There's no provision or recommendation associated with potential reopening of specialty areas. Like, so let's say bankruptcy doesn't make it for a few years, but then there's a resurgence in bankruptcy applications due to a recession.
Mm-hmm.
But there's no recommendation on that kind of review yet?
No, that is not included in the policy.
Okay.
And if the members decide that is an important piece of it, we could, the resolution could adopt the other 4 recommendations, and we could come back and have another discussion about this one and fold in something like that.
Understood. I think it's worth exploring simply because I think there is going to be a resurgence in certain areas that are currently low interest in the future.
Okay.
The motion.
Let's put the motion up, Adrian. I think what I'm hearing is that we should strike the 5th recommendation, and we can come back and talk about a policy for assessing the specialty areas that exist today with this general framework, and we can explore the recommendation that Dana included.
Does it need to be struck or just something else added at some point about the question of what happens when you want to reestablish a specialty?
Grace, are you saying we could flush out what that language should look like and add it to the recommendation? Sure.
The recommendation was fine.
Okay. Thoughts on that, what that policy could look like then? Is it maybe putting a certain year number of re-review or something like that?
Yeah, I don't know. What do you think?
I'd be inclined to put it on a 5-year review. think that's kind of cyclical and how a lot of that would happen.
Oh, I was thinking more like, for example, with the new, I can't remember what it was. The new specialty that was being
Privacy law?
privacy law. Like how that one was, however long it took, but it could be maybe a shortened process for a specialty that had already been established in the past.
Mhm.
I think that would probably, I think you could probably still adopt 5 as it is and then come back to that, because I think that would require a longer conversation, a longer assessment, right, as to what those provisions would be. But I agree, I think you can adopt 5 as it is and then come back to it.
And did you want to call that out in the resolution here?
I think that would make sense, because I do think it's necessary.
As part of that or as a new resolution?
I don't know, it kind of naturally fits as part of recommendation 5, I would think.
Any members have any recommendation on where?
I think you could do a semicolon perhaps, and then say that CBLS will assess whether to reopen the specialty area every 5 years.
I don't know if that's necessary. I just want to,
Just be open.
to assess something to be reopened. I would think that the people, if there was a demand, then they should be the ones to be proactive and request it to be reopened. And then my thought would be, since it's already been a specialty, it doesn't have to go through as long of a process as what we recently did with privacy law.
So something like, we will set standards for
We'll set
reopening
for reopening
previously certified
areas if there's a demand from members of that specialty, prior specialty.
Grace, are you saying then, just to connect the two recommendations here, are you saying essentially CBLS won't consider a request from the public to reopen a specialty area for 5 years, and then upon that 5 years, no?
No.
Okay. Sorry.
Oh, I think I was just taking it off, the burden off CBLS to actively look for specialties to reopen. If
Okay.
there's not a demand for it, I don't think that we automatically look for things to reopen every 5 years, after 5 years.
Okay.
My thinking is that if the public or needs it or attorneys want to reestablish it as a specialty, then they can do so. And then I think it doesn't have to go through as long of a process for vetting. Since it's already been established, I think if the demand comes back, then they can take an action to request it to come back.
Okay.
I'm hoping that makes sense.
Do we want to, is the ask then to just explicitly state here that CBLS will consider requests? And that's
Yes.
really it. There's no time.
There's no time limit. It's that if there's a request, that they'll consider the request to reopen closed specialties.
What if there's a request or on the board's own motion? Because, I mean, closing it off, right, doesn't mean an area couldn't be reopened, right? But I don't like to tie a lot of resources in that, and
You mean, so based on public need or based on the board's own motion?
you're right.
Yes, I think it's, AJ made it, CBLS will consider requests from the public to, or its own motion. Sorry, I'm trying to flesh this out visually. CBLS will consider requests I think we should make that clear from members of the public or from the public.
Mm.
Or may pass its own motion to reopen a closed specialty area. Something like that.
And Grace, I imagine what you were trying to say is you wanted to establish standards to create a truncated approval process to reopen.
Yeah.
Okay. So that we're not going through everything that we went through to try to seal off. Understood.
All right.
I think that's fine.
I think we need maybe a member to
Move to.
move. Yeah, sorry.
I
Thank you.
move to adopt language in the resolution.
Does anyone second?
I second it.
Can we get a roll call?
Alano,
Yes, I.
Bennett,
Yes.
Jenkins,
Yes.
Lloyd,
Yes.
Record,
Yes.
Surmitis.
Yes.
With 6 yeas, the motion passes.
I appreciate the adjustment because we keep coming back to Admiralty. Maritime has something to sunset. And LA has a very large harbor that's always active. Even though we kind of share data from North Carolina, Florida spots, but LA has a very active harbor.
Shall we take a break for lunch?
Seems like an appropriate time to break.
What time did you want to return?
What do we need? Say 12:30.
Okay.
Okay.
Where do we have lunch? Just.
Did you want to start quickly?
I'm going to. Go ahead, George.
Okay. Well, everyone, welcome back. And now we're going to begin our planning session and review of the 2025 initiatives and developments for our 26 work plan. I'm going to let Adrian take this over and introduce slides. Oop.
So for this item, we're going to look at the work plan for 2026 and really taking into account everything that was presented earlier today and discussing the priorities that we want to have for the following, for the upcoming CBLS. So for this, one notable change that I wanted to point out on the first page of the work plan, I think Cody said it earlier that he's going to be I think he said broken record, or he really wants to hammer this in, but the Board of Trustees, so we did add this to the Board of Trustees, they did direct the CBLS to identify legal specializations that increase access to justice. So I think that's one thing that we really want to focus on for the upcoming year. Another notable change to the work plan, we tried to reorganize it and structure it in a way that represents the two units that are supporting legal specialization. So we have the unit within the Office of Admissions that cover examination, development, and administration. And then we wanted to cover the initiatives for the legal specialization unit within the Office of Regulations and their tasks and their responsibilities. And then within those two units, we also wanted to look at one-time assignments, as well as any initiatives that may be recurring. So for examination development and administration one-time assignments, the first work plan is assess opportunity for possible new legal specialty areas and subject areas where there is a justice gap. For example, personal injury law or healthcare law, or otherwise meeting CBLS criteria and Board of Trustees directive. We had a tentative deadline of June 2026 to have additional information related to this work plan, but I wanted to see if there was any questions or comments or thoughts based on what was discussed earlier related to assessing the opportunities for possible new specialty areas.
Well, I feel like we need to kind of tackle one or two areas at a time because of the amount of work involved. But I do feel strongly that personal injury is a good candidate. It meets the criteria in the Justice Gap study. And it's an area that I think would really benefit consumers of a differentiating attorney.
I like that in healthcare. It's another area.
I don't know if this qualifies, maybe Cody or Grace, how you were saying about immigration. I don't know. Maybe we're overloading 2026 now, but
to include that?
Yeah, like maybe
I was thinking that too.
Yeah, I don't. We'll take the note and then we'll see if we can project workload or timelines. But I did think that was something that it was important that was called out earlier.
Texas has health law, I noted right now. And another one that might be considered in the future at some point is consumer law. I think that's a place where there's a bit of a bridge to gap, like gap to bridge. Yeah, I'm there.
Dean, are you saying that, because we could modify this and we could specifically call out what are we going to look at going into June? So it sounds like personal injury law is important to the chair. It sounds like healthcare law. Do you want to, I feel like I heard, do you want to add that as a third to explore this year? Or are you saying in the future that you want to maybe put it in the parking lot?
Well, I think immigration is a little more timely right now. So I would certainly defer consumer law to that if that's something we're going to explore. If not, and we think we have the bandwidth, then I would say consumer law. But I certainly, that's been around forever and hasn't changed a whole lot, whereas immigration is newer and has changed a lot recently. So
I'm wondering if we do bring up splitting immigration law into two areas, if we could also include somewhere the lower fees, I guess, that you brought up for the family-based in detention and section for immigration law, as it relates to access to justice.
I feel like almost any specialty, if someone can make that showing of I'm using my specialty to really serving the underserved, then that deserves consideration of a fee waiver.
I can tell you firsthand, like on the, what do you call it? I hate that term, boots on the ground, but immigration lawyers are taking the brunt of the, they're not getting paid more for the additional work necessitated by the constant, almost daily changes with the administration. So I think it would help if they don't also have to pay extra fees to help the population.
It'll be interesting to consider whether or not there could be some sort of pro bono requirement to legal specialization for some of these areas.
That'd be interesting.
Or considering that a portion of your work done is done modest means or sliding scale.
Yeah.
I had that thought too.
Yeah.
And maybe even if that was part of the recertification requirements, or if that could somehow maybe take some of your MCLE hours or something like that.
I agree with that.
And that's kind of what I got from that whole from the Justice Gap was the lack of pro bono attention And how can we integrate that? You know, it's probably more timely for some of the other issues we're going to discuss, but how do we integrate that into the specialization? You know, should we consider that to be expanded?
Healthcare, the reason I thought of healthcare was because of ACA being voted on, or possibly being removed. I don't know if in the coming year that's going to create issues for the population. I just don't, I haven't researched it, but I'm just voicing things that are coming to mind regarding that area.
We're definitely taking all these notes. I'm glad Cody mentioned that. So about me possibly placing something in a parking lot. I'm not sure all of that may specifically fit within opportunities for new legal specialty areas, but we'll definitely see where we can put that. And if we can add it somewhere else, maybe in its own initiative for the work plan.
Yeah, I think at some point we need something more specific on the fee issue.
Correct.
How that would be addressed, but it's a good.
And then just as a reminder too, so for what you're saying about pro bono, so the CBLS, they did approve a permanent waiver for specialists that are enrolled in the state bar's pro bono practice program, where they get their annual fees waived that year. So any year that they're enrolled in that program, we will waive their annual fee.
Do you know offhand the hours required?
I don't know, but I can definitely get that for you.
That's okay, if you knew.
But maybe we can do a better job of promoting that program too.
I think that would be a really good idea. I had no idea that existed.
One thing I should point out too, just because there's some great ideas floating out there. As we're going through this, you all might choose to deprioritize some of the things that we've started as a foundation here. So if any of these ideas brought forward feel more important, then let's also maybe talk about removing things from the work plan too.
And so are we saying that we're going to give some priority to personal injury, healthcare law, and breaking immigration into special? That is to explore.
I think what we're going to do is we'll have to bring back another work where we'll try to lay out, can we look at personal injury law and healthcare law and split up immigration? It may be because I'm hearing from the chair that personal injury law is important. Maybe it's we look at personal injury law and we look at the immigration piece. Maybe those are two priorities, and we could add healthcare law and consumer law to the parking lot, perhaps. Those are that's my idea. But if there's any thoughts about that,
Can you give a little elevator pitch on personal injury so I can understand why? Like, not that I don't think it's important, but just so we can have more motivation.
Well, I think it meets, we went through the criteria for the justice gap study. It meets that. And I mean, from what I see, there are a lot of personal injury attorneys in California, and a lot of ads and a lot of billboards, more than anything else.
That's true.
Right? I don't know how consumer.
Sweet James.
Right?
Never seen the man in court.
He's everywhere. Is that an LA thing?
That's
Everywhere.
thing.
Everywhere.
It's not in the Bay Area.
Yeah, it's Southern California.
So Sweet Jane. I love it.
But there's so many, and there's so much advertising, and I think it's beneficial to help people identify. Although I think what you're proposing in immigration is also really important. I think people need to be able to choose good immigration attorneys. And it's kind of keeping people out, right, from becoming specialists.
Right.
Can I ask, and maybe this is a bigger nexus question, so I apologize if this is a little bit off topic, but what I was kind of getting in the access to justice gap issue was financial. I felt like I was not it was a lot of the justice gap had to do with a lack
Can't
of,
afford.
I can't afford legal services, right? I mean, our low income population. Whereas I understand, for me, that would be something in healthcare where I would sit there and say, yes, that's immediately something that I would think somebody who is of limited means would deprioritize. Versus personal injury, the vast majority of those cases are taken on a contingency fee basis. I don't think people are normal. I just don't know that that's as important to legal specialization as something like healthcare, which is across the board something that impacts lives a little bit more. But and that may just be my lack of knowledge about personal injury law. I know it's more than just slip and falls at Walmart. but I don't know that much more.
That's a good point, though.
Yeah, that's true.
It was one of the areas, right, in the
Yeah.
study or.
Yeah, personal injury law and healthcare law were ranked as some of the top consumer areas in the Justice Gap study. That's why we kind of presented those as examples. And there has been some discussion, I believe, amongst members about personal injury laws that felt kind of serendipitous as well. But we also leave it to the members to kind of prioritize those two. And it also could be that we bring to you some initial information about those two options based on some of the standards before we kind of present a complete proposal, and maybe that lets you decide where
Bianca
to.
maybe could flesh out the personal injury piece a little
Yeah.
bit more,
Yeah.
tiny bit more.
Yeah, understand why they're not accessing those legal services in those particular realms. I think that would be very interesting to understand.
Excuse me. On this first initiative, any other comments, questions, or discussion? For the next one, I apologize, I think it does bleeds over to the second page, but review legal specialist examination design, administration, and grading. Some of the things that we specifically called out: consider exam design and grading modifications informed by psychometric best practices. Consider administration modifications informed by the 2025 post-exam survey. And identify the preferred exam delivery modality and vendor. And we were hoping or projecting to have that done by September of next year.
I don't find this to be a huge priority. And the reason is, I don't think a lot of people are going to choose whether or not to be a legal specialist based on the exam. It's got a pretty high pass rate.
Mm-hmm.
So it's not like we're sitting there, middling at 42%. We're almost at 3/4 pass rate.
Correct.
So is this just like, when I used to be in INLAC, just the actual, we wrote the test, but what would this actually involve? Exam design and grading?
So one would be, because this is our third remote exam administration, and then the way that it's scheduled, it can be a little difficult for, especially like the multiple choice question portion of the exam, because it's an odd number of questions, but then it's split into two sessions. So then you're getting 38 questions and 76 minutes for this session, and then you're coming back for 37 questions and then 74 minutes. Maybe we change it to 100 multiple choice questions.
So way
and then we
on the format.
Correct. That's one. And then for the grading, for the other exams administered by the state bar, there's a stated reconsideration policy. We do not have one for the legal specialist exam, but it was maybe discussing and considering if we wanted to have one in parallel.
And they want to have an appeal, or what is reconsideration?
The reconsideration policy for grades is if there is I don't know the specific wording. Yeah, an administrative error that resulted in an unsuccessful result. It could be looked at, but right now the rules are if the grades reported are final, so there's actually not even any type of reconsideration for the legal specialist exam.
I think it is important in the sense how things take so long, and since the exam is going to be, otherwise it would be, do we focus on it in early 2027, and that's the priority for 2027.
One thing I can offer that maybe helps break this down into more manageable pieces, I do think in 2026, we do need CBLS to weigh in on the vendor because we need to sign a contract with a vendor, whether it's the same one or a new one. And so that would require determining, do we want to do remote proctoring? Do we want to go back to record and review? And then we'd want to get proposals from the vendors, and we'd like to bring it to you all. And if we wait till 2027 to do that, the choices become more narrow because the on-ramp is smaller. So it could be that we just focus on that in 2026. And then we could table some of these exam design questions we could put that in the parking lot if that feels like it makes room for other priorities.
That deadline, actual month on that, what's the actual deadline for the vendor contract?
Well, we set a date to have that wrapped up at the September by September 2026. So that gives us about a year, a little over a year before the next administration for us to
Lock things in.
lock things in. Yes, exactly. And we tend to open up the application in like July. So, obviously we need to have all the details flushed out before July so we can turn the application
That's
on.
the real deadline.
Well, July of 2027, the next year.
Okay.
Yeah. So we would want things settled by September, then we would go into procurement mode, we get contracts signed, we'd be ready by July 2027 to open the application with all the information about what that exam would look like.
So it has to go to the Board of Trustees for approval as well. Correct?
The vendor?
Yes.
Not necessarily. The Board of Trustees role, if we took on a vendor, if the contract was over $50,000, they would approve of the funding request really, but they wouldn't weigh in on the vendor necessarily. So we could break this up. But I do think the vendor piece is kind of sort of a necessity from our vantage point.
Yeah.
Makes sense.
Comments, questions, or discussion on this? The last one for one-time assignments, review legal specialist examination rules and policies. And then we had another deadline of September 2026. This one would go to the board, the specific date or meeting. I guess it's dependent on when this is, when we can have something finalized. But this will go back to what I mentioned earlier about extending the results period. I think that the CBLS at the time, they also, there was at least one other legal specialist exam rule proposal that we could also look at one more time before we consider bringing them to the board for final approval. So, and we can look at the rules in whole to see if there's any other opportunity. Anyone have any immediate thoughts, comments, questions on that? Next group is going to be the exam development and administration recurring assignments. Excuse me. We wanted to conduct outreach about the legal specialization program, focusing outreach to affinity groups, local bar associations, newer attorneys, or other groups to increase participation by underrepresented groups identified in the analysis of the demographics of the certified specialists. Focus outreach to increase applications to specialty areas related to areas in which there is a justice gap. Outreach to potential accredited certification entities already offering specialization in areas identified as being impacted by access to justice issues to assess interest in becoming accredited. Anyone have any thoughts, comments, questions on any of that? And then this would be an ongoing one, which is why we had a recurring. I'm going to call out maybe, I don't know if it fits in here, but promoting the State Bar Pro Bono Practice Program. It's part of the outreach, but we'll take a look to see if it fits within this one or maybe it needs to be called out somewhere else. Next initiative, procure and retain diverse groups of subject matter experts to provide expertise and input specific to each legal specialization area for examination development and grading. This one is ongoing, but does anyone have any questions?
I do want to say that when related to that, when you offer like contract work, the pay is for attorneys is way too small. So
How much we're offering? You're
how
saying?
much we're offering, like if that could be brought up to the board of trust, it becomes not worth it to do, because I did exam writing one time and was paid enough, but it was a lot of work. And then subsequently, then we were offered like $15 for something, and it's not worth it. So you're going to not get quality, or you're not going to get volunteer. It'd be like almost pro bono work, or make it pro bono, or something.
You get your fees waived for the year.
Yeah,
True.
there's not enough incentive.
Okay.
For the kind of people who we want to be signing up for
Well,
it.
I remember before what they would offer and now what they would offer, and knowing the amount of work that went into it, it wasn't enough compensation for
Yeah,
the effort.
I think the fees were set when we transitioned from the volunteer model to the paid model, which has been a couple exam administrations. So we can,
Yeah, I
we
mean,
can
it's
look
been
at
a
those
while,
fees,
but
yeah.
I've never voiced it, but I'm voicing it now.
Yeah, we can definitely take a look at that. Or even possibly that fee. Any other comments, questions on that? Any other thoughts on, I guess it's exam development and administration initiatives? So next we'll go to the next group. So this is going to be the regulation team. So that's certification, recertification, and accreditation of certification entities. These are going to be their one-time assignments. Consider revisions to rules regarding enforcement and consequence for failure to appropriately remove designation or references to specialization. They wanted to have this done by September of 2026. Right now, there are no rules specifically for any consequence. We'll reach out, say, hey, we'll remind them of the rules. You removed from the program. State bar rules say you can't promote this. Please remove it. But there's no other penalty or anything associated to that. So,
Is it a huge issue?
it would be to the public. I would say so. Yeah.
Are lawyers that the bar know of actually holding themselves out?
We have. So I think it was a couple years ago. We worked with the Office of Chief Trial Counsel. They helped us draft a letter, kind of like a bucket, a template that we could send out, reminding them of the rules and that it could possibly lead to an investigation, which has been successful. So, but I think that the thought was that they wanted to have something specifically called out within the rules.
Perhaps memorializing what had previously been done. Is that the concept?
I apologize. Mia and her team are not here, so
Okay.
but I'll take the question. Any other questions, comments on that initiative?
I think particularly if now the new requirement may be for lawyers to have their books audited. So you may want to be clear about what you present to the public, if that may become an issue at that time.
What is that?
Fees. There was an MCLE class. I can't recall its title, but most of the California firms have to have mandatory audits. Those audits are, yes.
Audits for which one?
Yeah, so
The client,
Oh,
IOLTA
the
account.
trust. Oh, that
accounting,
awful
yeah.
thing I do I closed my IOLTA. because
okay.
There we go.
I use it,
Oh.
use it, and I have to
Yeah.
report the same amount every year.
Yeah, so, okay.
Their next one-time assignment, review the certification and recertification application form and process. And they hope to have updates to those by June of next year. I guess as specialists, looking at those applications, any thoughts, comments on the initiative or even the application itself?
It's long. That's about it. That's all I got. All right, so we can move to the certification, recertification, and accreditation recurring assignments. Excuse me. Procure and retain diverse groups of subject matter experts to provide expertise and input specific to each legal specialization area for working groups. And then with the working groups, so these are the subject matter experts that help staff
review applications, provide guidance or input on, I guess, special questions or circumstances that we would need support with. Anyone have any questions, comments on that initiative at all?
I just want to comment, and I think it's something that I've seen across a lot of these, is when we talk about diversity, we're not necessarily talking about age. I haven't seen that as like one of the standards when we're talking about choosing a diverse population. I just like to see that integrated into some of these and at least be part of the discussion.
Age, you're saying?
Yeah.
Yeah.
Because I feel like that's a little lost.
Right. What did we look at age earlier?
You know, a lot of our goals on work plans related to diversification come from the State Bar's strategic plan that has, like, for examination development, the goal to diversify the pool of developers and graders. I'm not sure it goes as far as defining exactly what demographic measurements we include in thinking about diversification. I think that leaves it open to all different sorts of measurements. But let me pull up our strategic report and see if it calls out age specifically. Then I think we, by nature, are already considering that when we're talking about our.
I just would say that we haven't. I don't necessarily see that reflected in the statistics that are presented.
Yeah.
So I
Can
just.
you explain more about that? You want to see more younger people?
I want to see more younger
older
people involved in the
practitioners?
process in terms of creating these tests. I want to see younger people in terms of grading these tests because there's a diversity of the way we think. You know, I certainly think differently than my 50-year-old, business partner as opposed to my 25-year-old baby associate. And we think in three different ways. And I think it's helpful to have that as we start thinking about the diversification process and making things more accessible to people and making them want to engage with legal specialization at all.
So Gen Z.
And Gen Alpha, apparently.
Gen Alpha.
God. I'll need I'll need somebody to teach me what their words mean, but.
I know, right? I'm still trying to figure out 6, 7.
But I do but I do think that's important just because I know with some of the grading and the way things are written in the exams, they feel some of the language is a little archaic.
Okay.
That's a better explanation.
Any other thoughts, comments on this initiative? Their last recurring item, review specialty area standards with working groups to determine if modifications are necessary. So this is making sure that the standards reflect the current practice of specialists in each area, and then can also tie into what Cody was mentioning earlier, if needed. If there are barriers within the standards, if there's something that can be modified to allow better access to that. So. Any thoughts, comments, questions on this initiative? All right, and then we can go to the work plan future items. Sorry, I think we were calling it a parking lot earlier. But we have for the exam development administration, this is what I mentioned earlier, I apologize. Establish a grading reconsideration policy in line with existing policies for other state bar administered exams. And then also opening the application for initial certification in privacy law. A little more of this will come in a later item that Janelle's going to present, which is why it's on the future item. It's not projected to occur in 2026. So, any questions on those two future items, or we do have some notes for things that we can possibly add to that future items as well, but any other thoughts or questions?
People actually asked for reconsideration and there were just no standards, or is that just simply to bring us in line with other certifying entities?
I know people have asked before and I directed them to the rule and then they pretty much dropped it.
Okay.
But yeah, I think it would be good, and it's also good for the applicants to be in line, to offer that, and then also be in line with the other policies for the other exams. Oh, you know, I apologize. Was there one more? There's one more. Sorry. Procure and retain new subject matter experts to provide expertise and input for developing the privacy law exam. So this also ties into privacy. So it's finding and procuring subject matter experts to develop that exam. Thoughts, comments, questions on any of this? Okay, we didn't have a motion presented, but I think that we may need one.
No, I think
Oh.
we could talk about it. I think if the work plan was not really modified substantially, that we could have adopted it here today. But I think you've given us kind of substantial things to look into, and that we may need to bring it back revised based on some of the priorities that you have shared with us. Because several of these items I think are going to require some research or reprioritizing of the work plan. So that won't mean I think we'll still have some business to bring to the next meeting to keep things on pace, but I think we should bring the work plan back with some of this feedback. Was there agreement on that?
Yes.
Yeah.
Okay. If everyone was okay with as it was today, we could have, I think, passed a motion, but I think there's enough here to look into and come back to with some proposed revisions.
You think March would time well with the other?
I think we'll just have to. Yeah.
So then our next meeting would be March, and then we'll bring this back to you.
Yeah, I think I'm not sure in previous years we've done this in practice, but the sub-entity work plans ultimately should go to the board of trustees, and they like ultimately will approve work plans. So that's why I think we'll want a formal resolution adopting the work plans that we can then take that to the board. But I don't think we can get that here today based on the feedback that we've received. So that'll be for the next meeting.
Then I think that's the end of this item.
Okay. So, now we go to Janelle to address the public comments and discussion in a privacy law.
Thank you. So at the December 2024 meeting, CBLS approved the privacy laws drafted standards. At the May 2025 Board of Trustees meeting, the privacy laws drafted standards were released for a 90-day public comment period. And at today's meeting, the CBLS will decide whether to approve the standards and recommend that the Board of Trustees adopt them with an effective date of January 1st, 2027. So here we look at the total amount of public comment we received. We received 4 in response to the proposal to establish a new specialty area in privacy law. Of those comments received, 1 submission was fully completed, where 3 were partially completed. 2 respondents expressed disagreement. 1 respondent agreed if modified, and the other respondent indicated no position. So 1 commenter, as you see, suggested using IAPP's CIPP exam to save cost, but the CBLS previously rejected it because it lacks California-specific content, doesn't clearly support public protection, and isn't tailored specifically to attorneys. So another commenter expressed general dissatisfaction with the state bar and argued that the privacy law specialization would have little public impact and would not advance the state bar's public protection mission. So we see the response to the comment 1 for the public protection. The privacy law group found growing risks to consumers in several key areas, including personal data sharing, emerging technologies, and cybersecurity threats. These issues are increasingly complex and make specialized legal expertise essential. So the 2024 California Justice Gap Study shows the urgency. Compromised personal information is among the top 3 consumer problems, impacting 45% of households. And also creating a privacy law specialty will ensure consumers can easily identify attorneys with proven expertise in this high demand area, as well as this specialization strengthens the state bar's public protection mission by promoting competent, knowledgeable legal representation in privacy related matters. So this, the adoption, the second comment, adoption of the IAPP, they previously applied and they became to become an accredited certification entity. The CBLS denied the application, stating that it did not specifically address the California-specific privacy law issues. The certification appeared to function more as a professional accreditation offered by a trade association without clearly demonstrating how it would protect the public. And the certification is also available to both attorneys and non-attorneys with no clear distinction for attorney-specific qualifications. So the cost of revenue for this examination, developing the initial exam will require a one-time cost of $37,200. And an ongoing exam-related cost would be $30,000 biannually for ongoing exam development, with $18,300 for the exam administration and grading, and it would total $48,300 covering both those two exam costs. With an estimated 35 applicants, that would generate $1,803 each, projecting an exam revenue of $63,000 beginning in 2029. And certification and recertification revenue would project it at $10,500 in the first year, increased by that every 2 years. Here we discuss the certification revenue and financial consideration. So the exam fees support the admissions fund, while the certification fees support the general fund. The certification fees will provide ongoing revenue as more attorneys become certified. The upfront costs will occur in 2027 to 2028 before revenue starts in 2029. The full cost recovery is expected by the second exam administration in 2031. So our next steps here, we see that there are a few public comments received. There's minimal substantive feedback that would warrant revisions to the proposed standards. The staff recommends that CBLS adopt the standards as originally proposed without any changes. And then the staff will further recommend that the board adopt the standards on the effective date of January 1st, 2027. So beginning on January 1st, 2027, just a little timeline here for us. The attorneys may apply for certification under the new standards. Then for the first 2 years, while we're developing the exam, we'll go ahead and have the alternative exam administration applying till January 1st, 2029. And then the first administration of the new privacy law specialty area will be expected in 2029, aligned with the end of the exam alternative period. This phase approach allows the specialty to launch promptly, which ensures adequate time to design a robust and reliable exam. Are there any questions on this?
Just one, are they adding the projected fees to the budget? The state bar's budget?
The revenue that's generated?
Are they adding it and counting it before the eggs are hatched? Or is actually
No, I don't.
tracking it and just waiting to really put it into the budget as something actually occurring?
The revenue from those fees, we haven't finalized our 2026 budget, but I don't think there's any anticipation of including that at this time. The Office of Finance has presented to like this committee of bar examiners the preliminary budget, and those assumptions were not included.
In the 35 persons, that's an estimate.
Yeah, let me maybe backstep and describe what our team did for this presentation. So previous discussions for the privacy law specialty area included an estimate, but the estimate was really based on the consulting group's estimates of a lifetime number of 500 specialists. But it really didn't, and so it talked about total revenue generated over the lifetime. It was not very clear. What we wanted to bring here today was here's what we expect in the short term and and annually based on averages of the different specialty areas, because we don't fully know the kind of rate of like interest? Will there be like a huge rush to apply? Will there not be? So we just use some averages to set that. The reason we think it was important to bring to you to at least consider and get some feedback on the financial component, because the Board of Trustees increased the application fee, because of the situation of the admissions fund, I think the board will just want to know that CBLS was aware of the kind of initial upfront costs, when the revenue starts, and if there's any concerns or feedback regarding that, we receive it. Otherwise, you're at least informed when you make this decision.
Thank you.
Questions?
Ready for the motion? Staff did prepare this motion.
Does someone want to make a motion to approve this? Yeah, does someone wish to make a motion?
I feel like I want to be reminded what the standards are. Is there a way, like a bullet list that you could read off prior to us making a motion?
They were attached. Let me see if I can open it.
Maybe do we want to put it on the screen then? Just so that it can be considered by the group.
Okay.
I don't know. I apologize. It's kind of long. There's 3 pages.
Oh, I see.
Yeah, but it mirrors the format of the standards that are in the rules for the other specialty areas.
Okay, no, that's fine. To get a I get a visual of it now. I understand what it is.
Yeah, so the consulting group proposed the task requirements for certification, the alternative for those 2 years prior to the exam, and then task requirements for recertification. And then CBLS already recommended those to the Board of Trustees. So this has been considered. I think it's been a long effort.
Okay.
Damon, I'll make a motion to approve. I think it was 4.5.
Right.
We have a second.
Second.
Roll call.
Alana,
Yes.
Bennett,
Yes.
Jenkins,
Approved.
Glory. Approved. Ruckert,
Yes.
Jermitis,
Approved.
6 yeas and 0 no's, the motion passes.
Okay. Now we go to Admiralty and Maritime law, an issue that's been discussed several times. See that ship has sailed.
He won
Go to Janelle.
All right. So the December 2022 CBLS meeting, the CBLS first considered closing the Admiralty and Maritime Law specialty area to new applicants. And at the August and December 2024 meeting, the CBLS revisited the issue, considering data showing declining engagement and reduced revenue. So at today's meeting, we asked the CBLS recommend staff to begin the process of possibly closing the Admiralty and Maritime specialty area to new applicants. And once no certified specialists remain, recommend that the board sunset the specialty area. So here we look at the rationale for closing the specialty area. We've had a persistent lack of interest, ongoing exam development costs. It is a niche field, serving limited attorneys and consumers, as well as a similar action has been taken due to this issue by other jurisdictions. So as you recall, at the December 2024 meeting, staff presented the poll findings, which are included in that attachment A. For the board's reference, we have summarized the key findings from attachment A as a brief refresher. So out of 22 then certified specialists, there was 12 respondents providing meaningful insight on the future of the specialty area. 75% of the respondents opposed closing the specialty, reflecting strong support for maintaining the area. Every current specialist opposed closing the specialty, reflecting strong support. Oh, sorry, maintaining, I repeated. Every current specialist opposed closure, showing commitment for those actively practicing in the field. About 50% supported allowing certification only, suggesting a compromise of maintaining the specialty for existing members while stopping new certifications. The specialty is highly niche, as we stated earlier, and limited public awareness and potential applicants. Continuing legal education opportunities are limited and making it harder to support specialty development and ongoing engagement. There is an increased promotion to raise awareness of the specialist among the public and prospective applicants as we develop partnerships with industry groups to also broaden the outreach and engagement and broaden the scope of the specialty, including related practice areas, which could attract more candidates and increase relevance. Most specialists don't want to close the area, but there are still problems with awareness, getting new specialists, and the CLE opportunities. So looking here at the data trends from 2019 to current, we see that participation has disappeared with 0 candidates in the last 2 exam cycles. There hasn't been one since 2021. The exam costs and work overload persist even when no one or one applicant decides to take the test. In 2025, there's no exam expenses or revenue, as you see here, due to there was no one who took the 2023 exam. So we were just going to use due to the absence of applicants. The number of certified specialists have dropped from 35 in 2029 to 19 today. This declining population further undermines the specialty's ability to support exam development, recruit candidates, as well as maintain a meaningful engagement. So staff reached out to other jurisdictions asking the question of how they took up part in handling this matter if they have. So North Carolina found that updating the standards could help, but noted improvements are needed and are long-term. The Florida structured a sunset rule. Closing reflects the situation here. They had not had applicants for many years provide a closing of the area while allowing specialists to continue to recertify. So as we move to our next steps, staff directs to close the Admiralty and Maritime Law specialty to new applicants. Once no certified specialists remain, they recommend the board to permanently sunset the specialty area. If no additional action is needed, staff will post the notice. And if amendments are needed to Title II, Division 2, Chapter 2, Article 10 are needed, staff will return to CBLS for further action. Are there any questions?
Would you be removing the word or language permanent based on our earlier conversations on this next steps?
Based on our conversation about still considering application or public requests.
Mhm.
Yeah, and let's see, I don't think our resolution is that specific, so let's see here.
The language sunset, probably based on the earlier conversation, we'd want to strike.
Well, so the intention there was that once, I guess that's an interesting scenario to consider. If there's no individual still recertifying, I think the example we talked about earlier, to me, felt more like a system that was continuing to operate even when there's not new applicants. We may reopen it to new applicants, but we're still recertifying existing specialists. I think the intention of the component here is that if once the program goes completely dormant, that it should be sunset. I would think of that scenario as allowing someone to submit an application for this specialty area again in the future if they wanted. It would then to Grace's point, it would go through the full application process. It wouldn't be this kind of like shorter assessment, or it wouldn't just be CBS consideration. It'd be an application.
It was sunset.
Yes. But I guess the intention there is that a completely dormant program, I don't think should be on the books just for.
And
For no
sunset
reason.
laws, when, in my experience, sunset laws come back, like sunsetted immigration or estate planning laws. So it's not so permanent, but I agree with, permanent also caught my attention.
Yeah, and that's what I did. The language permanent seemed to me to be, final and potentially deter
Right.
interest in the
deterrent,
future.
yeah.
And that's what I don't want to do is if there are people who have that interest and want them to sit there and say, oh, they already killed it once, so I don't really want to go for round
Yeah.
two.
And use their
Can we see the proposed recommendation, please?
Yeah, maybe that we could add just a similar language that we added to the other resolution that allowed for that consideration during.
The permanently wasn't included here.
Oh,
And should our response be based on California language? Even though you consider Florida, you consider Texas, you consider the other states that was
Oh, you're-
as a primary law, California
you mean
versus the other.
the California, the recommendation of within 2 exam cycles that there were no applicants, that language?
I think we were just presenting those as a reference point. Not necessarily, yeah.
Oh, okay.
California.
We could say in this resolution that because there has not been enrollment for the previous 2 exam administrations, which is now the recommendation that was adopted earlier today, that is the reason that CBLS is adopting the resolution. That could align some of what's been discussed today. And then to Dana's point, maybe we can bring in that piece of language from the earlier resolution regarding CBLS open to requests to reopen a program. We could include that here as well. Maybe that bridges the gap between the different policies today.
We'll consider requests from the public or by CBLS motion to reopen the legal specialization. By the public or by CBLS motion.
Oh,
You
sorry.
need to,
Yeah.
you need to keep the words closed in the 1, 2, 3, 4th line. Or no? Idling.
What's the word then?
I think it is closed. It's just a closure to new applicants. It's not a
Close to new
decertification.
applicants,
Right,
yeah,
right.
the sunset would be a different
Perfect.
reason to end, it's a different ending.
When we say reopen, if it's already sunsetted, how does that work?
Reestablish,
Or would this be before an actual sunset?
Yeah, it's kind of a term of art, isn't it?
I mean, that the CBLS will consider piece could be brought up before when no certified members remain, and it could relate to just the period before the board sunsets a specialty area.
Yeah, that's a long sentence.
Yeah, this is the hard, this is the hard part.
or it could be a
I-
new sentence.
How about we do new applicants?
Let me just ask, do we have to put in the sunset provision at all? I mean, couldn't we get to a point where, there are no more?
Mhm.
And then at that point, just say, let's close it out? Like, do we need to add that provision in now?
Well,
I think the sunset makes sense. I think that reopen could be after sunsetting. I mean, it could be there's a change in 10 years where there's this resurgence of Admiralty and Maritime law and it's sunsetted. So I don't know that then it sounds like you can't reopen it after sunset. I was thinking you could reopen it after sunsetting potentially.
Oh, so you're saying put it back at the end?
Yeah, like it's not so, that sunsetting isn't final necessarily.
Well, that's what I was thinking, if we don't have the language sunset, we just sit there and say it's closed. We meander around for a couple of years after it's closed.
Well,
and we're
close
still-
to new applicants, but I agree to Cody's point, like you don't want it like lingering there.
Sure, but I'm saying make that determination later on as opposed to adding the language in now and creating some sort of final consideration, because things could change substantially in that period. I mean, I assume there's at least one or two young guns who are Admiralty specialists. Might be around for a while.
Closing it to new applicants.
Maybe.
Is there
Live.
any- if it's closing new applicants, is there anything to do?
Anything for
Anything the staff has to do? If the program is closed to new applicants, is it like functionally
the
sunsetted?
regulation team will continue to recertify and certify
Yeah.
or recertify
see.
existing specialists.
Mhm.
Individuals won't be able to sit for the exam, which then essentially closes off additional certifications.
That's the.
I'm just thinking about the sunset thing.
And I think, Dana, what you're saying is like, why don't we could just take up that business
When it becomes
when
applicable,
it's, yeah.
as opposed to making it a necessary function of this resolution. We can close it, we can sunset it, where we can move towards sunsetting
When
it
there's
as
the
a-
last, when we see there's no more people who are
Exactly.
certifying, then we announce the
Exactly.
sunsetting of the program.
Exactly.
Because once it rolls off and there aren't specialists left, right, then there's nothing to do anyway.
There will be nothing for staff to do. That will certainly be a trigger for staff to come to CBLS and say, why is this here? So we could deal with it at that time if that feels appropriate.
It may actually feel, just in terms of
Okay.
the Admiralty people who are currently there, it probably feels better for us to not be like, by the way, it's gonna be gone afterward too. Since they largely opposed closing it, it seemed like.
So to new applicants, period, then, that would be the resolution.
I think it could still include this the addition of the requests. So in the interim,
Mhm.
Oh, I
if a
see.
member makes a compelling case and CLS wants to reopen it, they could do so.
Yeah.
Okay.
Yeah,
The whichever occurs first, is that, it's, I'm not, the grammar, something about it is, or the stylistic is kind of bothering me.
I don't know that we need whatever occurs first. It just can be opened by either public
Yeah.
or CBLS.
Yeah.
Short and sweet.
Adrian, this is the hardest part of the job. Taking feedback and typing it in real time.
Look good? Do you want a clean version?
It's beautiful.
you want to make a motion?
Absolutely. I move to adopt the resolution as written.
And a second.
I second it.
Okay.
The second.
All right, Alano,
Yes, approve.
Bennett, Jenkins,
Approve.
Glory,
Approved.
Record, Surmitis,
Approve.
with 6 yeas and 0 noes, the motion passes.
Well, that's the end of our open session items. The closed session. But I want to thank everyone for coming here and attending. Nice to see all of you in person. The current time is 1:33 p.m. The meeting is adjourned. I remind everyone that the next meeting will be via Zoom on March 20th, 2026 at 10 a.m.
Be here before you know it.